guess we'll start this with the roll call, and that will be the board.
Jeff Rinaldi, present. Member.
Pokey Booth, present.
Alex Leader, Vice Chair.
Kathy Ditzler, Chair, present.
Linda Zazziger, Secretary Treasurer, present.
Neil Hoffman, Board Member, present.
Deborah Jones, Board Member, present.
Vince Jimno, Executive Director.
Sarah Bradley, Deputy Attorney General.
Deputy Attorney General.
Gloria Alexander, Office Manager.
Deborah Blasco, Accountant.
I guess it's my understanding that we have a new law with agenda item number 1, comments by the general public. If we have any, I'm going to ask
Madam
you to
Chair,
speak
maybe I
now.
can help clarify too. The legislature has changed the law to allow public comment or any on whatever they want to talk about, except for the items that are on the agenda. So if you have any comment you'd like to make to the board that you prefer to do it now, you can do it now. There'll be a second opportunity at the end of the meeting for public comment to be received again by the board. And it's intended to make sure that the public has an opportunity to say their piece at any given meeting. But if it's on the agenda, then you'll be given an opportunity later in the day. We can't discuss that item until it's brought up for discussion, and then we'll let you know if you have the right to make a comment at that time or not.
I'd also like to make note that we also have a couple of other members from the board up here too. Would you like to introduce yourself? Sure.
I'm Inspector and Office Assistant 1, Charlie Marsh.
Darlene Scott, Inspector 1.
Thank you. Okay, is there any comments? Okay, that takes us on to item number 2, consideration and approval of the agenda and its posting.
It has been posted in accordance with open meeting law requirements.
Madam Chair, with that in mind from Ms. Blasco, I make a motion to consider and approve the agenda and its posting.
Second.
Motion made by Mr. Leader, seconded by Ms. Booth. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries. Item 3, consideration and approval of board meeting minutes for June 13th, 2011. Do I have a second?
I'll second.
Motion made by Member Booth, seconded by Member Leader. Any discussion?
Ms. Blasco, I'll just give you 2 or 3 modest changes.
Okay.
All in favor?
Aye.
Any opposed? It's my understanding we have 3 cases that are being taken out of our agenda today.
Yes, we do. Item number 4, Janine Marie Jones. Item number 6, Sharon Pincolini. And item number 7, Madeline Nichols.
Madam Chair.
Yes.
I would request that we do item number 12 first, if we may. I have one witness here that will be here only for that case, and I thought it might be nice to let him testify and be on his way.
So then we would be starting with number 12.
If we could, please.
Okay. At this time, the board will begin its disciplinary hearings. When you hear your case called, please step forward and take a seat at the table. We have a court reporter here who will swear in all witnesses. She will also take down everything that is said in the hearing. She can only take down one person at a time, so it is very important that only one person speak at a time. The state will go first and present its case. You will be given the opportunity to ask questions of the state's witness. After the state has completed its case, you will be given the opportunity to present your case. The board may also ask questions, and the board will deliberate and make a decision. And I'm going to ask that everyone turn all cell phones off. So that takes us to item 12.
Yes, please.
Nevada State Board of Cosmetology versus Peter Vance Hellisbury. Administrative hearing for alleged violations of NRS 644.430, 1A and/or NRS 644.430, 1K, and/or NRS 644.476, and/or NAC 644.711.
Is Mr. Van Salisbury here?
Madam Deputy Attorney General, we have not been notified by any representative or Mr. Salisbury himself that he would be here or not.
Well, in his absence, then, I have exhibits 1 through 10 that I would like to have admitted.
So made it.
And I will pass them out. Okay.
Don't you pass them on?
Sure.
Ms. Bradley, do we expect to discuss it in his absence?
Yes. We'll talk about that next.
Okay. And in the allegation number 15, it said the girl at the Cosmo board can hook me up. Is she present?
That's part of the case.
Yeah. Can you just
Oh, okay.
wait for just a second, and we'll go ahead and we'll do our best to answer the questions. There's also an extra copy for Mr. Ward and the court reporter and the witnesses.
And is the Exhibit 1 any different than the complaint and notice of hearing that we received earlier?
No, however, if you look towards the back, there are copies of the mailing information for the complaint notice of hearing.
Just those copies for witnesses. Everybody's got them.
Yeah, there's a copy for the witnesses, which I think will be Ms. Alexander for these.
You want me to pass these out too?
Yes. You might as well just go ahead and do all of them. Oh, there's a copy for you too.
Can I, is there enough that I have it for the court package?
Did you want to see it? I didn't get this option.
What did you get?
I got the exhibit.
And so the exhibits reflect the content of the complaint?
There?
That substantiates the content of
I mean, they should help you with that, yes.
There. Gloria needs it too.
Good, Jim.
No, well, yeah, we're going to. But
Sarah. Yes. Should be an extra 3 because I don't have a 3 in my license. Oh, there's my 3. There's Nancy. I think you might have an extra. No, that's the only 3.
oh, this is the only 3?
Yeah.
Okay.
Okay. Six. 7. 8.
Bill and Forrest.
Yeah, the 9.
Yeah.
I guess that's fine.
I can do it. I can identify it properly. You should have pictures of 7, 8, and 9. I don't have those.
You need mine?
7, 8, 9, 10. You only have one copy.
Yeah. I have 9, so I don't have 10. And I don't have 7. Okay. I don't have 7.
Madam Chair, I believe you said that exhibits 1 through 10 are admitted?
Yes.
Okay, and for the record, can I go through for the board and identify each of the exhibits?
Yes.
Thank you. The first exhibit is, Exhibit 1, is a complaint notice of hearing in this case that was prepared and sent to Mr. Van Salisbury. If you look at the last page of the exhibit, you can see mailing information when my office sent the complaint notice of hearing to Mr. Van Salisbury, and it was for return. Exhibit 2 is a printout of the ad that's at issue in this case that was on Craigslist.
Ms. Bradley, with all due respect, were they returned because of the 89052 or 89502, the transposition there of the zip code? Because that's not the correct zip code. So while the street might exist, the zip code doesn't.
That was what the address, I believe, that I,
Is it an insufficient address because of the 89502?
I'm not sure. Yeah, it does look like that was mentioned. You'd think that the post office would be able to identify the zip code.
Does that make a difference?
Yeah, I would say it does.
May I please, Ward, Madam President, Harry Ward for the record, PhD. It's up to you, Ms. Bradley, whether you want to pursue this. I know you do have a witness in regards to the ad get proper service, but that is going to be up to you to make that decision.
Yeah. And it would also be up to the respondent to contest that he wasn't properly served
Right.
after the fact.
And for clarification from the audience too, in a lawsuit or in a disciplinary hearing, you have the right to serve someone. When they don't show up, the board can take action without their presence. Of course, the prosecutor must prove and show and establish that this person at least had knowledge or they intended to give this person knowledge of this hearing.
Yes, thank you. And I was actually, after I did the exhibits, I was going to make a motion or request a motion that we proceed in his absence. But let me continue for the record going through the exhibits. So we have the advertisement at issue. Exhibit 3 is a notification sent to Craigslist that the advertisement should be removed. Exhibit 4 is a statement prepared by Gloria Alexander. Exhibit 5 is our printouts of text messages received by Ms. Alexander on her cell phone. Exhibit 6 is also a text message received by Ms. Alexander on her cell phone. Exhibit 7 is a copy of material in the respondent's licensing file. Exhibit 8 is information about reciprocity and how respondent's original application for licensure. Exhibit 9 is from the Department of Law and Public Safety in the state of New Jersey, and it shows the status of respondent's license in New Jersey. And then Exhibit 10 is the just alerts listed for respondent's license currently with the board office.
Ms. Bradley, I'd like to make a note that on Exhibit 7, page 2, it has a copy of the Mr. Ben Salisbury's license, where the zip code is 89502, and I believe it was sent to that. Oh, 52. Both of them?
Sarah, can I ask a question? Couldn't we hear all the information and then maybe actually table it till the next meeting to actually vote on it and give them the opportunity to show up?
I'd rather not do that. So what I would like to request is that the board make a motion to proceed in the respondent's absence pursuant to NRS 622A, which allows the board to proceed in a hearing in a respondent's absence after they've been received proper legal notice. This matter was noticed on the board agenda. It's available on the website. It is sent to all interested parties. We did attempt to notice him. I have a hard time thinking that the post office can't look at a situation like that and realize that something was transposed.
Can I ask one more question?
Yes, ma'am.
You're representing us.
Correct.
What do you feel about this?
Harry Ward for the record. May it please the board, Madam Chairperson, just to let you know what the law is also. You can make a decision today, and then when the respondent receives a copy of your decision, he has 30 days to appeal it. So this is not his last-ditch effort. He would have the right to appeal that decision. As you well know, we are in the United States, and you have the right to appeal these. These would go to the district court. So he would have actually 30 days plus an extra 3 days once he receives it. So it's going to be up to the board. If you feel comfortable with pursuing it and listening to the evidence from all the witnesses, then you have the right in your deliberations to talk about it. For example, someone may say, well, I don't feel that we should pursue this because we don't have an accurate address, or I don't like what's on here. Or someone could say, well, I've listened to the witness and said, the witness has testified that this person is long since gone, so I feel comfortable. So that's going to be up to the board to make its decision in the deliberations. But to let you know, there is an appeal process.
Yes.
Also.
And normally I like to have you make the decision that legal notice has been given so we can proceed. I do have a witness here that's here specifically for this case. The other information is the person can file a motion for rehearing or reconsideration within 15 days. So it's possible that if the respondent believes there was an error, that sort of motion can be filed.
Do we need a motion to go on?
I believe you do need a motion to proceed to hear the evidence in the person's absence, because then it's considered a default hearing, and a default hearing means that, you know, you hear it in the person's absence. So I believe you do need that motion.
Is Mr. Salisbury a current licensee?
Yes.
And is he maintaining his current license at this time and working in a licensed establishment? The one that he claimed to be working in says that he's not
Well,
working.
we have testimony that we'll talk about where we think his whereabouts are and where we think he might be working. So, I mean, I think we can answer some of those questions later. But if you look at Exhibit 10, his license is active and expires June 29, 2012.
Excuse me, Ms. Bradley, and the police board and Madam Chairperson. It might be better for us to proceed, you could just go on and put on your witness to establish service, and then the board can then make a motion whether to say, yes, we believe this person has had proper service, and continue with the hearing.
I don't have a witness regarding service because the witness would be my assistant in Carson City.
Okay, but then you would be able to give argument, and then the board can make,
Yeah.
I guess, a
I don't have a
decision.
problem making the motion. I make a motion that we move forward.
I'll second that motion.
Got a motion made by member Booth, seconded by member Leader. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries. We move on.
First, I would like to call Ms. Gloria Alexander.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? I do.
Ms. Alexander, would you please state your name and spell your last name for the record?
My name is Gloria Alexander, Alexander.
And who is your employer?
Nevada State Board of Cosmetology.
And what is your job title?
I am an office manager.
As office manager for the State Board of Cosmetology, what are your duties?
I provide administrative support to the executive director in performing any special projects and duties that he may assign to me. I also supervise the administrative staff.
Okay. And in the course of your duties as office manager, did you become aware of a licensee named Peter Van Salisbury?
Yes.
And how did that happen?
We received an anonymous call from the Reno office in reference to an ad on Craigslist.
Okay. And so then that complaint was forwarded to you in Las Vegas?
Yes.
And then what did you do?
It was assigned to an investigator in the Las Vegas office.
Okay, and can you please walk us through the steps of the board's investigation?
On April 20th, 2011, the board received an anonymous call, and on April 21st, the Reno office located their Craigslist advertisement and sent it to the Las Vegas office. The advertisement read that cosmetology license for sale and gave a phone number of 719-352-5718. On or about April 21st, the inspector assigned to the matter for the Las Vegas office contacted the Craigslist and reported that the ad that was being offered was illegal and requested that the advertisement be removed from the Craigslist. On about April 22nd, the inspector found that the advertisement had in fact been removed. On April 22nd, in researching the phone number provided, the advertisement, the inspector learned that it was located in the Colorado Springs area. On about April 22nd, the office manager, which is myself, called the number that was listed.
Okay, and so when you called, who answered the phone?
A man answered the phone and identified himself as Peter.
And what did he tell you?
He indicated that he was an instructor from Paul Mixture and that he is able to provide national and Nevada cosmetology license for a fee.
And what else did he tell you?
He told me he was located in the Reno area.
And what else did he tell you?
I then asked Peter how much it would cost to get the license, and he indicated that it would be $1,000 and up. And I also asked him if he had all three other licenses, which was nanotechnology, esthetician, as well as cosmetology. And he stated to me that he did. And I also asked him if I would send him additional customers, if he would give me a discount on the price of the license, and he indicated that he would. He also told me that they were original licensed with the Nevada State Board of Cosmetology seal on them.
And did he also mention somebody at the board office was helping him with this?
Yes, he indicated that there was a girl at the Cosmo board that could hook us up with the license.
Okay. And then did you ask him for a sample?
Yes, I did. I asked him if he would send me a sample, and he told me if I would agree to meet him, he would be able to show me a sample of the license. At that time, I explained to Peter that I was not in the Reno area.
And did you give him your email address?
Yes, I did. I gave him my personal email address, which was galexander03@hotmail.com.
Okay. And then what happened?
On April 22nd, I received 3 text messages from Peter. And the first one, Peter wrote, the email sounds great. It's yours if you would like it. And he was referring to the cosmetology license. And the second one, he wrote, I think you can look it up on the Cosmo site. And he gives me his PIN number. And he said, thanks, hope you're having a good one. And
in that second message, the number that he gave you, you recognized as a board license number?
Yes, I did.
Okay. And then what did the third message say?
The third message said that he was flexible on the price.
And when you looked up the board license number 25181, what did you find?
I found that license number was assigned to Peter Van Salisbury.
And so that matched the name that he gave you, when it said Peter?
Yes.
Okay. And did the board records have an address for the respondent?
Yes, it did.
And what was the address? Number 25, I think.
The board record revealed that his address is at 49 Park Street in Reno, Nevada.
And was that zip code 89052?
89052, correct.
And is his license current?
Yes.
When does it expire?
His license expired June 29, 2012.
And did the board's records reveal how respondent obtained licensure?
Yes, it revealed that he got his original license through reciprocity from New Jersey.
And what else can you tell us about his licensure application?
The original application was notarized in the state of Colorado with the same area code as 719. That was the phone number that was on the Craigslist.
Okay. And when was his license last renewed, according to the board records?
According to board records, it was last renewed September 7, 2010.
And did he provide an employer record in that renewal?
Yes, he did. In that renewal, he stated that he was employed at Robert Richards Salon in Reno.
And did you locate respondent's name listed in the inspection sheet for Robert Richards Salon?
There was his name did not appear on the inspection sheet from the salon.
And what did the board's investigation reveal about the status of respondent's New Jersey license?
The inspector learned that his original license was from New Jersey, and the number was 32WG03799-300, and that it expired, and it was issued on April 9, 2001, and it expires on September 30th, 2006.
And did the information found show a last known address related for respondent on that?
Yes, the last known address for the respondent was New Jersey in Pueblo, Colorado.
For the New Jersey license was
Okay.
Okay. And that would be probably the same area code, that 719.
Yes.
And did the board's investigation find any other interesting information in respondent's licensing file?
Yes. In his original 2004 licensing application, he indicated that he was subject to court order child support and that he was in compliance. in his 2007 and 2010 license renewal document, he indicated that he was not subject to court order for child support.
Okay. And then did you receive any further communication from respondent?
Yes, I received a fourth text message from Peter stating for $500 the Cosmo license could be mine. And he told me they was as real as they get. It had the state seal, and it was also on the special paper that we used, and that it was 100% legit.
Okay. And did he also leave you a voicemail?
Yes. He was asking if I was still interested in purchasing the Cosmo license, and he indicated that I could look the license up, the license number online.
And then what happened?
On June 1st, 2011, this matter was referred to the Attorney General's Office for Criminal Investigation by the Attorney General's Division.
And did you prepare a statement regarding your involvement with this case?
I did.
Okay. And as of today's date, what is the last known address that the board's records show for respondent?
It shows that he's at 49 Park Street, Reno, Nevada.
Okay. Okay. Thank you, Ms. Alexander.
Do we have a question on Ms. Alexander? Is
Oh,
now a
yes,
good
you
time?
can. You can question her. I forgot. I apologize.
Ms. Alexander, I just wanted to double check on two things that you may have said. When you looked at the phone number, the 719, in the earlier part of your testimony, did you say that the phone number was from Colorado or that the individual was in Colorado?
The phone number was, the individual was in Colorado.
At that time? And then I just wanted to double check in your testimony when you referred to the address being on item number 25. Do you recall that? It's a little different than when you look at the address on item 43. And so I just want to confirm that the address that you're providing for Mr. Salisbury is the number 43 address.
Okay, 49 Park Street in Reno, Nevada. And it's the same, number 25. The record revealed that he's located at 49 Park Street, Reno, Nevada. They're the same.
Okay.
May I ask a brief follow-up question?
Yes.
Unless the board has other questions.
The only question I had is the last two messages received, the last text message and the voicemail, what were the dates for those?
The last two. May 4th, 2011.
And you don't have a date for a voicemail, but it was after that.
It was, yeah. It was after May 4th. that
Okay,
was sent
so
voice.
sometime between the last text message and when
Right.
you turned it over to the AG's office.
Right.
Okay, thank you.
Ms. Alexander, on Exhibit 4, is this the actual conversation that you had?
That's your statement.
Yes, this is my statement, yes.
So we do not have any actual proof that he's ever sold a license to anyone. I mean, we inventoried our licenses, we account for all our licenses, our blank ones.
Yes. We have, I believe we've been able to account for all of our license, except for the last, I think, 7. And those could have been destroyed in, like sometimes we put the license in the machine, and the machine will eat them, or they could have been shredded. But at this point, we will have a handle on all of our licenses and can account for them.
So but as I said, we have no facts that he actually was able to sell one.
Not to my knowledge.
Okay, thank you.
Pardon me. From an accounting background, I know when we manage checks, we have a log for the last check number and the ending check number. And do we not have that for our license numbers, first and last? We keep a log of what's been issued?
At this time, we do, yes.
We do, okay.
Any more questions? Did you want to
I wanted to ask one follow-up question, Ms. Alexander, I think based on something Mr. Leader asked her. I believe, I just want to clarify that the board's investigation, when the research was done, the board investigator learned that 719 was a Colorado area code, I believe. Do you remember that? So the phone number originated in Colorado, and he could have been located anywhere using his cell phone.
But this is the phone number that was listed on the correct list and the one that we used.
Exactly, and so that phone number is tied to Colorado, as was respondent's last known address for his New Jersey license. So somehow there's a tie between respondent and Colorado.
I think that was brought out in the investigation.
Yeah. So we don't know where he was when the phone call happened.
No.
We just know that the phone number you called had a 719 area code, which is a Colorado phone number. Yeah.
Excuse me, I have another question. Relative to, I have someone at the State Board office. Have we investigated that?
I believe the investigator did address that issue.
So that if that hole that was broken is now closed, we don't have someone in our establishment that can...
No, I don't think it was ever proven that there was someone in our agency that was actually tied to Mr. Salisbury.
There was someone?
No, there was.
And I think we have another witness that might talk about that a little bit.
Would that mean that a license could not have ever been sold, that he was trying to sell something that he had nothing?
I wasn't the investigator on this, but I do believe Mr. Salisbury, everything that I've seen, he was referring to his own personal license.
Yeah, I think we can talk about that a little bit more with the next witness. And I think that's why if you look at complaint notice of hearing, we say upon information and belief. We weren't really able, I believe, to substantiate what exactly he was doing. We just know that he was saying he could sell these. It may have been, initially I think the concern was that he was manufacturing many and trying to sell many. But I think after the investigation, as it went on, it sort of became more evident, or it seemed that he was maybe just trying to sell his personal one before he left the state.
I see.
That's, I believe, the number that he gave.
Madam Chair, Vince Jimno, Executive Director. In the interest of making sure that we cross the T's and dot the I's, I would recommend the board ask specific questions of Ms. Alexander's particular testimony. And those questions that the investigator would respond to, will we listen to that testimony first, then ask the question.
Okay. And then I just have one last question of Ms. Alexander. Is there a procedure in place for you to confirm or verify whether someone is subject to court-ordered child, the child payment that you referred to, that his current application indicated that he was not subject to that court-ordered payment? So is there a process to follow up on that?
When someone renews a license, they make the statement whether they were current or they're not. If they're not current on their child support, then I believe there's an agency that would report that to.
And so no reporting needed to take place because he indicated that there was no subject.
He was not subject to child support, yes.
Thank you.
The next witness I would call is Mr. Wayne Casino.
I solemnly swear or affirm that the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth.
I do.
Mr. Casino, would you please state your name and spell your last name for the record?
Wayne Fazzino, F-A-Z-Z-I-N-O.
And who is your employer?
The Attorney General.
And what is your job title?
I'm a special investigator assigned to the Criminal Division.
And how long have you had that position?
11 years.
And do you have any other law enforcement experience?
I do. I have 36 years of law enforcement experience. Prior experience as a DA investigator, and then I started with Los Angeles Police Department.
And as an investigator for the state of Nevada, what are your duties?
I investigate mostly state employees involved in crime, would be the first item. Second item, we do conflict of interest with other agencies. Let's say the district attorney has a cousin that's involved in a crime, and we would investigate that matter for them. And I also, in my past, have done boards and commissions.
Okay. And so in the course of your duties as an investigator, did you become aware of a cosmetology board licensee named Peter Van Salisbury?
Yes.
And how did that happen?
I was assigned a case in June of this year to investigate allegations that Mr. Van Salisbury was selling illegal cosmetology licenses, and number two, that we may have had a state employee that was compromising his or her position in providing those licenses to him.
And so did you open an investigation?
I did.
And what did you do next?
What I originally had to do in reference to this phone number was write a search warrant seizure order, and in order to obtain those records from AT&T, which I did.
Okay, and what did that record search reveal?
Those records came back. I was able to capture toll records and also phone records coming in, calls going out. And the purpose of that was to try to connect those to an employee of the agency to see if anybody in the agency was in contact with Mr. Van Salisbury.
And did you think anybody was after that?
That's only the first one. The second one, I was eventually able to get Mr. Van Salisbury's cell phone number, and what I did is I went to 49 Park Street, South Park Street, which is, I believe, the Parkway Lodge. He had been gone supposedly since December of last year, and I verified that with an elderly gentleman who lives in the apartment building next door, who indicated that he was close friends with Mr. Van Salisbury and his girlfriend, and her name is Jennifer Brennan. That will be important here in a moment. And this man also indicated that he last spoke to Jennifer prior to her leaving, and he received a phone call from her December of last year on the cell phone number.
And was that cell phone number the 719-352?
No, the cell phone number was a different cell phone number.
Okay.
That belonged to Mr. Van Salisbury. That was his personal cell phone number. The problem with obtaining records there was that was a track phone. And a track phone is one of those phones that you can buy and pay each month. They did not, or were not able to provide subscriber information on that. However, they were able to provide phone calls going from the phone out and phone calls coming in. I took those phone numbers also and tried to match those to employees with the board in reference to numbers that Inspector Green from the board provided to me of employees, their home numbers, cell phone numbers, and the other numbers that he was able to obtain. And I was not able to make any connection at all, which leads me to believe that Mr. Van Salisbury most likely did not have somebody with the agency that was providing information to him. So he had already been gone when Ms. Bradley sent him the information. He was long gone. He'd been gone at least 6 months prior to that. He was no longer at that address. I verified that also with a lady in a salon that's right across the street called, I believe, Zelda's. I spoke with her and she says, no, he's been gone a long time. Spoke to the maintenance man at 49 Broadway. He'd been gone a long time. Spoke to an older woman in a wheelchair in an apartment building next door that I was driving around just talking to people trying to find Peter. And she says, no, he's been gone, but talk to this other gentleman behind there, and that's the man that provided me with the information on Peter and with Jennifer Brennan.
So your investigation revealed that he left the state well before the complaint notice of hearing were.
Correct.
And also it sounds like he left the state before the phone call with Ms. Alexander in April occurred.
Correct.
Okay, and what else did your investigation reveal?
The phone number, 719-352-5718. The person liable for that is a William Van Salisbury out of New Jersey. And I called that number, and as soon as I spoke to him and identified myself, and I got the typical, we don't know him. They hung up right away. I called a number of the phone calls that came in and have gone out to talk to people, and they said they didn't know who he was. Well, obviously his friends were covering. covering for him. I left numerous messages telling him that there was a hearing coming up, and I needed to speak with him to see if, in fact, I wanted mostly to address the issue of, was there somebody with this agency that was selling licenses? That became my focus after.
But were you able to tie that phone number to respondent?
Yes, I did. There were two agencies that I was able to go through. First was the Rocky Mountain Information Network, which is a law enforcement, federally funded law enforcement agency, and there's 6 of them throughout the country. They have access to numerous databases. So when I spoke to them, they were able to come up with the utility bill showing Peter Van Salisbury having an address in Colorado on a street called Alvarado, and I can give you the exact address if you need it.
Using that phone number?
Using that phone number. That phone number was connected to his name. The phone number, the liability was a William Van Salisbury for that number. We were also to show Jennifer Brennan, his girlfriend, using that number in New Jersey and in Colorado. So we do have a solid connection there. And then we also ran him on LexisNexis, which is another agency, and they also provided a number of indications that that number was being used by him. And I verified that also through Social Security number and date of birth with the name, so that was solid.
Do you have any other information that your investigation revealed that you'd like to share with the board?
Just that we ended up closing the case out because we couldn't get a hold of him, but the case is, even though we closed it, we're still going to keep it open because if he does come up, I still want to talk to him, and especially about why he made those representations. We may not prosecute him on the misdemeanor of trying to sell the license, but I do want to speak to him to see if we do have a problem, which I don't believe we do.
Is Brennan a licensee?
Not that I'm aware of.
And you did confirm in your research of the phone numbers that that phone number was making the initial phone calls to Miss Alexander?
Yes, I did. Yes.
So while you didn't confirm that there was another contact, you did confirm the conversations with Miss Alexander?
Exact dates and times that Miss Alexander provided me when she spoke to Peter, I was able to show through the phone records.
I had a question. So the Attorney General's office is closing this case?
It's closed.
Okay.
The criminal division has closed the case, yes.
Thank you.
I have a question also, Neil Hoffman, board member. What's the statute of limitations with regards to this particular misdemeanor, as you called it?
I believe it's a year.
Okay. Thank you.
However, if there's misconduct on the part of a state employee, that would be a felony. So
with regards to anybody else that's
Correct.
supposedly helping him?
Correct, so I could tie it back in that way.
Okay. And then you also said about a track phone. Is it possible that any this phantom state employee could use a track phone as well that wouldn't be tied to the numbers that you had?
Well,
that's possible.
As far as subscriber information for the phantom employee, I may not be able to get that, but I would be able to get the phone numbers.
Right off the numbers that you had
Correct.
on his cell phone.
Going back and forth.
Correct.
Yes.
Did anybody ever try to give him money to see if they got a real license, to see what kind of licensing we get back from this gentleman?
That would have been with Miss Alexander.
Yeah. Actually, from your investigation, it didn't appear that any license would have ever really even taken place. It sounds, if I'm hearing you correctly. And I really appreciate the fact that you continue to want to speak to him. I just really admire that because there are a lot of open-ended questions, and I just think that that's a very admirable thing to do from our law enforcement. And I hope that other people recognize that too, that that's a really excellent characteristic that you have. Thank you.
Well, it's not me. I mean, the idea is that with the Attorney General, we get a lot of complaints that never rise to a level of a crime, but we still have to investigate them. And what's always worked for me is calling a person and being honest and saying, hey, they're sending me over here to talk to you. How do I get you out the middle of this thing? And 99% of the time, people will be truthful. And they'll tell me this. You can't get me out of that, but you can get me out of this. And then we just document it. We're just fact finders. not to get people.
And then also, real quick, so you called several times, so despite the address discrepancy that we discussed previously, he's been more than notified that he needed to speak to somebody about what his
I
actions
have called
were.
probably 8 times.
Okay.
And up until last week also.
Okay.
I tried to reach him again. The other thing, before I leave, I'd like to at least make this comment that I received excellent assistance from Miss Alexander and Inspector Green and from the director on this case. And the fact that Miss Alexander did an incredible job prior to us even getting involved in it was really helpful to us for her documentation. So I thought the board should know that.
Thank you. Thank you for letting us know that.
Any more questions for Mr. Casino? I'd like to do a little bit of a closing statement, if I might. Sure. I would submit that based on the testimony you've heard, the factual allegations in the complaint are true, as are the violations of law. I would also submit to the board that the discrepancy with the address may have been rectified. It may not have been the zip code alone that caused the post office to make that notation. I don't know the reason for that, but I feel like based on Mr. Casino's numerous phone calls to the respondent and the fact that the respondent's name was noted on the agenda and posted properly, that we tried our best to notify him of the hearing. And so I would hope that those facts would help to show that he has been given proper notice. And I would remind the board that if the respondent has a concern about what happens here today, there are both post-hearing motions he can file and an appeal that he can file. So I believe based on the testimony, though, even if we'd had an address, it still would have come back because Mr. Casino found that he left back in December. And this complaint was sent out on December of last year, and this was sent on September of this year, September 23rd. So it sounds like even if the zip code had been different, the post office still would have returned it to us. And I will note that when we send any order that the board enters, we'll ensure that the zip code is double-checked. That is the only address we have for him. We don't have a new address in Colorado or anywhere else to send it. So we'll do our best to resend it there, but it's sounding like from Mr. Casino's testimony, that's going to come back as well. So.
More importantly, Ms. Bradley, what was the investigation? What did it reveal about the child support?
I don't know that there was an investigation about the child support. I think it was just noted in the investigation that on the original application, he indicated that he was subject to an order.
Right.
And then in the renewal, he said he wasn't. And so it just seemed kind of maybe odd. I mean, certainly a child could age out and there could be a legitimate reason, but.
And are we going to refer that component of his application to whoever we refer that to?
I don't think so.
Because if the application is, if there's a lying on the application, that's a whole separate thing than whatever else he's doing.
Well, I mean, I think we have sufficient violations here. I mean, there are 5 violations. Attempting to alter or copy a license, which is grounds for disciplinary action. Again, there's 2 different references for that, an NRS and an NAC. And then also, again, trying to use his license for fraudulent, deceptive, or illegal purposes. I mean, that's, again, grounds for disciplinary action.
Right, but he's still, I'd still like to be under a clear footing with the original application that he's lying about his obligation for child support, too.
I think we would have to have additional information before that's something we pursue. I mean, because again, just because in 2006 you say that you have child support, in 2010 you might not. I mean, if the child's turned 18, you may not be subject to an order anymore. So we don't know that was a lie. It just seems a little bit odd, and it makes you wonder, a little bit. But I mean, I don't know that's something we know. We have no complaints or allegations that he did lie. And the final violation we have is based on Mr. Casino's testimony and the fact that the phone number has been tied to Colorado now, is that he hasn't provided the board with his new information, which is required within 30 days under your law. So, I mean, I think we have a lot of violations here. When it gets time for you to ask me what my recommended penalty is, I have a pretty severe recommendation that I'd like to make. So, I guess I feel like we could add more on top of the mountain, but I think we have enough.
I'd love to hear you. Oh, I'm sorry.
I just have one question of the charges. We have proof that he was copying and selling his license. Do we have proof of that?
Well, I understand all the other charges. That's the only one.
Well, that's why it says by attempting to copy or alter, by attempting to copy or alter. I mean, if you don't think he did that.
That's how the law reads.
I think the law says copy or alter, but I mean, we think that he was attempting to do that. I don't know that we have proof that he actually ever did. And then it's, by attempting to use an altered or copied license for fraudulent purposes. I mean, it sounds like, again, I mean, it's up to you. He's not here to
I understand. I just didn't
Yeah.
see anything in the documentation that there was a copy.
I mean, we just know that he was offering a license for sale. He said it would be legitimate. It would look like it. It would have the real seal. He gave a number. He said, this is the number it's going to be. You can look it up online. So it sounds to me, in the end, like he was going to get rid of the information and add, whatever else.
Well, I have no problem with all the other, it was just I didn't see
Yeah,
documentation.
no, we don't have actual exhibits about that.
Thank you.
Bradley, I'd like to make a comment. Vince Jimno, Executive Director. In most legal terms, when you attempt or do overt activities involving a particular violation, the court's usually considered as the same as the violation itself. Whether you actually do it or not is considered. Mr. Fazzino would have followed that easily just as soon as he saw any kind of evidence on both the what we call the federal deadbeat law, which is the child support. That's to find them is all they do that for. The DA's officer usually use that. But I saw no connection either. And Mr. Fazzino did a nice job of taking every avenue to try to get the information. But in technicality, if you say you're going to do a crime, I'm going to commit a burglary, and I take overt act to do some part of that burglary, but I never get to do it, it's still the same crime.
Can I ask one question of our legal counsel?
Sure.
Because as a board member, I don't want to get into a position where I blow this case because of one item.
May it please the board, Madam Chairperson, maybe I can address it this way. After Ms. Bradley has finished her closing, I think then the board can then go and make a motion to accept the facts. Go, if you want to go through each one or eliminate the facts, and then individually go through each count violation of law, have a vote, have discussions, and then you have voted on all the facts and all the violations of law, and I think you're covered. And then from there, I think if there is a violation found, then I think Ms. Bradley will be making a recommendation, and then it'll come back to the board for their vote, consideration, deliberation on the violation.
This is kind of my
Does
question.
that answer your question?
A little bit.
And I apologize.
So if I go with all 5 of those, and the one we don't have the proof on, would that throw the whole case out if we, no?
No, it would not. You would have a finding of fact that the state or Ms. Bradley has not proven one violation, but they've proven other violations.
I didn't want to leave one little flaw in the pie that could change it all.
Are you saying then that we can do all of them at the same time?
I would recommend you not do them all at the same time.
Each individual.
Correct, but you may want to do all the facts at one time. For example, I think we have 44 facts. Someone may on the board say, I don't think we've proven fact number 25, and then vote, discussion, vote, and then maybe accept the others. So I would recommend to the board, go through the facts first, decide in globo all the ones that you agree on. The ones you don't, maybe there's a motion, we'll work from that vote on that fact saying we don't think we've proven this fact. Then go on to each violation separately and do likewise jump to each vote and discussion.
Thank you.
You're welcome.
I was just going to ask what your recommendation was, but it sounds like we have some other.
I think that would be
We have
premature.
we have to agree on the facts previously too. Okay, so
I have one question, Mr. Jimno. Did he receive his Nevada license through reciprocity?
Originally, yes.
Okay, thank you.
I don't think I have anything more in closing. It's just our position that all the facts and all the violations have been proven by the testimony. We do have some things that are alleged by information and belief based on the investigation of Mr. Fazzino and the information that Ms. Alexander discovered. So, we have alleged those the best we can, and I believe that he's not here to dispute them, and so I think it can still be proper for the board to find those statements to be true. And again, the violations of law, I mean, if you read them carefully, it's that he attempted to do this because he did offer out to sell the license, and there's conversations about that. So we believe he was attempting to do something inappropriate for sure. And so we have listed it out like that. The fourth claim for relief kind of has everything in there, and that's the unfair, unjust practice or method or dealing. And I think it's clear that, even if he didn't complete the act, I mean, he was attempting to do something inappropriate.
And you put it in writing too, that's good too.
Yeah, and the same is true for the third claim for relief, which again, that talks about fraudulent, deceptive, or illegal purposes. I mean, that was what, there was an attempt here. And then the fifth claim has to do with him not changing his address, and providing a new employer and or a new business address while his license is active. So I do believe we've proven the facts, and we would ask that the board do find all 44 facts true and all 5 violations to have occurred. Thank you.
Madam Chair, I'd like to make a motion that the respondent is in fact guilty of NRS 644.475.
Second?
I'll second.
Excuse me, please, board. I think we should go with the facts first and just deal with the motion to find the fact that these facts are accurate, and then from there move on to the violations. That would be my recommendation.
Madam Chair, I'll withdraw my motion.
I'll withdraw my second.
Thank you.
I would advise board, let's go with the facts first and then make your motions and discussions.
Madam Chair, I'd like to make a motion that the facts presented in the case reflect the accuracy of the investigation and the complaint. And I would then still move that the respondent did violate NRS 644.475.
Okay, we'll do the,
I'll second,
I was-
oh, I'm sorry.
I'll second the motion.
okay, motion made by member Leader, seconded by member Hoffman, to find the facts warranted in this case.
Madam
Any
Chair,
discussion?
I'd like to ask a question of Mr. Ward. Would it be more comfortable to just accept the facts as they were in the report, as entire its entirety, or leaving out the ones or two that they don't like?
Yes, sir. I guess to clarify, I think it would be a lot clearer that the board would make a factual finding on just the facts and say we either accept all 44 or we accept all 44 but for this one certain number. Have a decision on the facts. So you made a fact-finding decision, and then I would recommend you go to each one of the claims. You would say, all right, let's go with first claim, second claim, third claim, fourth claim, fifth claim. That way the record would be a lot clearer in the event that this matter is appealed.
And
Thank you,
the
sir.
same is true for the order, because of the board order that I'm going to draft after you make everything here. We include the facts that you found to be true. So it's helpful for me, and I think for the court reporter, if you say facts 1 through 44 are proven, or facts 1 through 20 are proven, and then you want to argue about 21. However you'd like to do it, but I think it's helpful if you do the facts separate and you do them by number.
So I will modify my second motion to exclude the respondent violating NRS 644.475 and just include in my motion that the facts numbers 1 through 44 are accurate, except for item number 25 with the typo of the zip code.
Did you want to?
Yeah, and I'll second that. Yeah.
So let me understand, we're accepting the facts of 1 through 44 minus item 5.
25.
Minus 25, sorry.
And my understanding has been seconded and is now open for discussion.
Yes.
Well, are you requesting that factual allegation be changed and it's proven if it's...
I think it's a typo. I think that
I
it is.
have information from the board office in an investigative report that gave me that zip code. So it may be a typo, but I mean, you want to completely throw it out, or do you want to amend that fact to make the zip code correct?
I think it's reflected in item 43. The correct zip code is reflected in 43. So
Okay.
to me, it just appears that item 25 is just a typo. It's not. It doesn't change the facts for me.
Do we need to do anything other than what's been said?
Well, there was a motion and a second.
There's a
Yes.
motion and a second in discussion. If the discussion is finished, maybe you may call for a vote, or you want to keep discussion open.
Is there any discussion? Everybody's okay with that? Okay, I will call for a vote. All those in
Aye.
favor?
Aye.
Any opposed? Motion carries.
So then I'll make a second motion, or third, fourth, and find that the respondent did in fact violate that first claim of relief, NRS 644.475.
Second.
Motion made by member Leader, seconded by member Rinaldi. Any discussion? Booth? Oh, I'm sorry. Member Booth. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries.
Make a motion to approve 644.711.
I'll second.
Motion made by member Booth, seconded by member Jones. Any discussion?
I just would like to clarify that motion that the respondent violated that NAC.
You're making a friendly amendment to my motion?
Or clarification.
It's a friendly one, right?
Very.
I accept.
All those in favor?
Aye.
Any opposed? Motion carries. Third claim for relief.
I'll make a motion that the respondent did violate that third claim for relief, NAC 644.711, number 2, more specifically using that license for misrepresentation.
Do I have a second?
I'll second that.
Motion made by member Leader, seconded by member Hoffman. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries. Item 4, fourth claim of relief.
I'll make a motion that he violated the claim of relief, claim for NAC code 644.711.
I'll second.
Motion made by member Hoffman, seconded by member Jones. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries. The fifth claim for relief.
I'd make that motion that that respondent did violate NRS 644.300.
Seconded.
I'll second.
Motion made by member Leader, seconded by member Booth. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries. Now we'll move on to the penalty phase.
Yes. My recommendation would be that the respondent's license be revoked. NRS 622A requires that if the board does a revocation, that a time period be specified, and the time period that must be specified must be at least 1 year and not more than 10. I would ask that the license be revoked for 10 years, which is the maximum time period. I would also ask that the board assess costs pursuant to NRS 622-400. Costs in this case incurred by the board not to exceed $1,000 with an exact total to be provided to the respondent in the order. I don't have an affidavit currently with a list of all my costs, but I believe that would hopefully cover all of my costs.
Ms. Bradley, does that include the cost of the investigation? The $1,000? I mean, that seems like quite a bit of an investigation for $1,000.
I don't know how Mr. Vizino bills. I don't know if you bill. Do you bill board?
That's what I'm aware of.
Okay, so there's no costs incurred by your investigation.
But there's still a taxpayer cost. I mean, somebody is still jeopardizing the public at the taxpayer's expense to warrant the Attorney General's office to assign an investigator.
Well, but the only cost that you can assess are costs that you actually pay. So since you're not going to pay something for Mr. Vizino, you can't assess those costs against him.
Thank you.
And my costs are tabulated and, you billed for them every month. And so I can tell you exactly how much time I spent on this case. If you keep track of Mr. Green and Ms. Alexander's time on this case, I think you can also recover for their costs. And I don't know if their costs have been tracked or not.
And they're paid from licensee fees.
Yeah.
So realistically, licensees' fees have gone to pay staff to investigate somebody's fraudulent activity.
I mean, yes, and so if they've kept track, and if you know Mr. Green spent 3 hours and Ms. Alexander spent 2, you can include that in your cost award. I don't know if their time has been separately allocated like mine has been.
Madam Chair, maybe I can respond and clarify the issue, much like Mr. Fazzino's response. Part of keeping the integrity of the government's operation and to be sure that there is no crimes or violations being made, we inherit that cost as part of the investigative fees that are already built into the system. We do pay extra for the attorney's services. That's billed monthly. Mr. Fazzino, if he sent us a bill to support their operation, then we would legitimately be able to add to it. But not getting that bill, I think the Attorney General's office status is much like ours. It is part of doing the business of keeping the board honest and integrity in place.
I please the board and Madam Chairperson, everyone is correct. Basically, you can assess the statutory fine, but if we have anything that's documented in regards to costs, which would be Ms. Bradley's cost for prosecuting it, you can add that on. But anything that's speculative would be considered arbitrary or capricious, and we wouldn't be able to prove it in a court of law. So I would say, yes, you are limited to your fine, statutory fine, and whatever we can prove in billing in regards to this case. And likewise, and just for a little something in the future, if you are going to suspend his license, I recommend that you put, for example, 30 days from the date that he receives the license. That's when it will begin. This gives him an ample opportunity to appeal it, so it doesn't come back from a high court saying, well, you didn't give him an opportunity to appeal this decision. You just suspended it immediately.
Yeah. So what I would recommend is, the way normally when I draft an order, I say the order's effective upon receipt or 15 days from the date of the order. So I think you would want the revocation to start 45 days from today approximately. That gives us time. Well, anyway, 45 days from the date of the order. How about that? And then, the cost be assessed not to exceed $1,000. That would also include Mr. Ward's time during this hearing and my time during the complaint and all of the things I've done. And then the 10 years, revocation, which is the max time period. If the board doesn't want to revoke the license for the max time period, I would ask that a fine be imposed, and you are authorized to do $2,000 per violation. But since he's left the state, he's not here, we may not even be able to contact him. I'm not sure assessing a fine is really going to be in our best interest. So that's why I think the max revocation period is more appropriate.
Can't we do both, though, Sarah?
You can fine and revoke him and assess costs against him if you want.
Because in that way, if he ever came back to the state of Nevada, we could recoup the taxpayers' money.
I mean, a fine is different than costs, though.
It goes away after a period of time?
Well, no, it's just different. I mean, costs go to the board's budget. A fine goes to the general fund. A fine is more punitive. Costs are reimbursement for the board. So,
my question is, can we fine him as well as do the 10 years, and if he ever came back to the state of Nevada to try to work, he'd have to pay that fine back?
I mean, you could, but that might be excessive. I mean, I guess my recommendation is if you're going to fine him if you're going to revoke him for 10 years, then my recommendation is that you don't fine him.
Because it is
that you do assess costs. I mean, I do think costs should be assessed no matter what. But my recommendation is if you're going to revoke someone for 10 years, that's a pretty stiff penalty. And so I would recommend that we don't fine him in addition to that.
I think putting the general public in jeopardy is pretty serious. But so, because it's a misdemeanor, is that why you're making that recommendation?
I'm not making any recommendation based on criminal, because as far as I'm concerned, it's an administrative case. It's regarding the licensee. So I'm just saying a 10-year revocation is the stiffest penalty I've ever had in any case I've worked on in my more than 4 years with the office. So I'm asking for that because I think that this was a criminal case, and so I think that because he was doing such severe activity, that a 10-year revocation is appropriate. And I'm doing a trade-off in my mind, because I would have said, well, let's fine him, say, $2,000 per violation, because this is serious. That's a $10,000 fine. But I'm willing to trade it in my mind and go, okay, well, let's do a 10-year revocation and not do a fine.
See,
because revocation keeps him out of the public. To me, that keeps the public the most safe, because he can't work in the state of Nevada for 10 years, period.
And that's a national license up.
And if his license is revoked, he would not be able to make and pay the fine.
I mean, it's up to the board what they want to do. That's just my recommendation.
In my mind, I think they're both linked as well. In fact, I'd like to make a motion if I could.
It's a big motion.
I propose a motion that not only do we revoke his license for 10 years, but we do fine him $2,000 for each violation, which was 5, for the total of $10,000. I think that that's appropriate in this particular case. This is pretty egregious. It's pretty obvious that he was attempting to do this online. So that's my motion.
I'll second.
Madam Chair, there's also a comment.
Okay, motion made by member Hoffman, seconded by member Benaldi for a total of a $10,000 fine and revoke the license for 10 years.
Yeah.
May it please the board, Madam Chairperson, was that including cost? Was that discussed?
Well,
or-
I think the cost should be added as well, so I can amend my motion to adding the costs as well.
To advise the board, yes, it would have to be in that motion.
Okay.
And not to exceed, I think we should say the cost should not exceed $1,000 since I don't have the accurate amount, but that way the record can reflect the max liability for the respondent.
Mr. Hoffman, is that part of your motion?
That is part of my, let me amend my motion to include the cost of the Assistant District or Attorney General's office.
And you want to, you're going to second that, Ms. Benaldi?
Madam
Okay, to amend the motion to add the cost not to exceed $1,000, and seconded by member Benaldi.
Madam Chair,
And open for discussion.
I would like, I want to clarify how you do that, because I'm concerned that Mr. Ward has explained the process that would be more clear for the court should it ever be appealed. That is that you are finding on each violation guilty, right?
Yes.
And the fine for each violation, if you're going to add a fine, is added to each violation separately.
Correct.
And then, and the fact that the court costs are in a final motion, so it brings it all together and the court can easily separate out each violation. I think it'll be cleaner and it will be less problematic if one of the fines, the court disagrees with the board's decision, it can be easily adjudicated that way.
Do you want us, is what you're asking is that you want us to do each count separate?
I would acquiesce to Mr. Ward's instructions, but I think that there's some value.
Yeah, if it may please the board, Madam Chairperson. I agree. I think it might be cleaner to go through each one. One, you made it, finding the fact of violations. Go back and then also assess a fine for each one that you do believe that he is guilty of. And that way, if it does go up to a high court, the court can say, well, I think they would be proper, they didn't prove this, we'll just subtract whatever amount is from the total amount. So it would make it a much cleaner record. So that would be my recommendation. A little more work to go through each one of the counts and make a decision if you are going to fine, and if so, what amount.
You don't have to make a motion each time. I think you can make one big motion that says, for count 1, a $2,000 fine, for count 2, a $2,000 fine.
That would be acceptable.
So should I withdraw my motion and restart it? Is that what we're
That would be.
Yeah.
Okay, fair
I think
enough.
Ms. Jones wanted to say something earlier, too.
Yeah, I had a question about reciprocity with our fines and our findings. Do we not notify the other states that we have and they don't notify us?
Unless they're contacted to get a license from us.
Exactly.
Because that's what they normally do, is they contact the state previous.
His license in New Jersey is not active. If it was active, I would ask that that be sent to New Jersey because they should know if you've done discipline on a person with an active license. But we have no information that he's active anywhere else. And so for now, it wouldn't go anywhere. It might be a good idea to check Colorado and see if they have an online verification. And if he's active in Colorado, we can send it to the licensing board there. It is public information. And I think all licensing boards have a right to know discipline on their active licensees.
Ms. Bradley, I wanted to clarify, it sounds like there's 4 components to this motion that you're asking us to make. The first component is the fine structure. The second component is the revocation for an X number of time period or duration. The third component is the assessment of costs with a not to exceed amount. And then finally, the fourth component is when it should all begin, and there was a recommendation of 45 days from the date of the order.
Yes.
So that's the content of the motion. The motion would have to contain those elements in order to be a valid motion.
And you could, if you wanted, separate the cost out. Sometimes there's a guilty, like a penalty motion and a cost motion. And you could even do the effective. If you want to do 3 motions, you can.
It sounds like it can all be rolled.
It can all be done in one. It's just a lot to say.
What I do want to ask is once we do on each of these counts, we do the fine. Do we do the revoking of the license? Do we do that separate?
It all depends on the motion, I guess that's what we're all saying. If the motion includes everything, you get a second, you discuss it, and then vote on it. If the motion does not include everything, let's say you do 1, 2, 3, and 4, fine, costs, revocation, and time limit, then you get 4 separate motions. So it all depends on the motion before the board.
Okay, I will call for a motion then.
I'd like to propose a motion to revoke the license of the individual in the discussion between Van Salzburg.
Motion made to revoke license.
Is there a time limit?
Did the 45 days proposed?
No,
or-
how long?
How long? I'm sorry, yes, 10 years, yes, 10 years.
Okay, motion made by Member Hoffman, seconded by Member Benaldi, to revoke the license of Mr. Salisbury and for 10 years, right?
Correct.
Starting in 45 days from the date of order. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries.
Okay, I'll make a motion that there be a $2,000 fine per claim or per violation of law
Do you want to give
per-
us
for all 5, each one individual. Can I say it that way? Each individual violation, there be a $2,000 fine
For a total of,
for a total of $10,000 plus attorney's fees not to exceed $1,000, starting 45 days from
Date of order.
date of order.
I'll second.
motion made by Member Booth, I'm not going to repeat, and seconded by Member Heziger. Any discussion?
I would like to clarify that in Ms. Member Booth's motion that she indicated attorney's fees, and I'd like to clarify that to be all costs.
is that a friendly amendment, board members?
Yes.
Is there a
Do you
second?
accept that, Linda?
Yes, I accept that.
All those in favor?
Aye.
Any opposed?
Nay.
Motion carried.
And can I ask for one more thing?
Oh.
Oh, we can, okay, thank you. I feel so much better.
Oh, would the board also like to make a motion on whether or not the matter can be sent to collection if it's not paid within a certain time period? You can add a time period for the payment of the fine and the costs, and if it's not paid, you can institute collection actions and/or send it to the controller's office, because the controller's office has a process to try to collect debts.
Yeah.
So I don't know if that's something the board wants to add, but if you do,
Well,
please.
I believe we'd like to, but there was 2 other parts to the progression of this. We've revoked the license, we've decided on fines, so what else?
I think you've accomplished them with 2 motions.
Okay, perfect.
So the next, I guess, discussion would be, I think, Attorney General Bradley is asking.
Because normally I know for an active
question.
license, we wouldn't do something like that because the board is going to get the money when the person does a renewal. But in this case, the person is left. So I'm thinking you may want a mechanism to try to collect.
And I think if you did a security check on this person, then that would come up. And so I think for the protection of the public, that should go out there to a collection agency because a security check would show any collections.
Ms. Bradley, can we make the motion that it could be, the collection process can be best way? Is that like best practices?
Or just let
Like,
the Attorney General's office take care of it.
So,
Well, our office doesn't do collection, but the controller's
Or
office
the
does.
controller's
and do they have a system in place that's considered best practice?
Madam Chair, there's 2 processes the Controller's Office allows. We normally are left alone to collect ourselves because we have a higher collection rate because we won't renew licenses without the fines being paid. In this case, we would automatically just send it to the collection system of the Controller's Office. So it's neither, whether you have to make a motion or not is not as critical as it's just flagged immediately as within a certain period we consider it a dead account and we move it directly to them.
So that's something that would be done automatically?
Yeah.
Well,
Oh,
it should be included in your board order, especially if it's appealed. And best practice would be included in the order. So since we've already said that the fines are in effect until 45 days from the date of the order, I think the board needs to determine how long should the person have to pay, 90 days? And then after 90 days, it goes to collection, or do you want 60 days, 30 days, whatever you
Well,
want?
let's ask this question, how long do we normally do it at the board?
We don't normally do it. We ask for an exemption of the controller's office that allows us to collect our own accounts that are not, accounts receivable not paid. In this case, what you're doing really is giving direction to the staff of how long that period should be. That's really all the bottom line. And if Sarah feels more comfortable, Ms. Bradley feels more comfortable with being in the order, so it's more defensible, that's more than appropriate.
So what time limit would you think would be?
I would recommend 90 days from the 45. So the fine is effective in 45 days from the date of the order. The person has 90 days to pay it only because it's such a large amount is why I'm giving 90 days. And then after 90 days, it would be sent to the controller's office or other collection action be taken as deemed by the board office.
Member Jones?
Yes, in accordance to best practices in accounting, 120 days is considered collectible.
Yeah, so that would be, that would be 135 days.
Yeah.
What we're saying is 135.
I make a motion that we turn this over to collections after 120 days from 45 days from the time that they've been notified and had the opportunity to appeal.
So you're giving them 120 days to pay from the 45-day mark.
From 45 days.
And then if they don't pay within 120, then it goes to
the controller's office for collection.
or other action.
Yes. Or other appropriate
I
action.
second the motion.
A motion made by Member Booth, seconded by Member Hoffman. Any discussion?
Mr. Juneau, do you have another recommendation?
No, that's fine. Yeah. We would only hold it on the books for a reasonable period, no more than 6 months anyway. But 145 days, you're closing very quickly on the 6-month level anyway. So it's a matter of just flagging it for that 145 days. It's not
Do
a
you
problem.
prefer that time frame be cut in half or anything?
No, I don't see any real collection. They go through a much more extensive collection process. They assign people to start tracking people down, which we don't. We sit and wait until a renewal comes in, and then they can't get the license repaired until they pay the fines. So.
And in this particular motion, does it present any hardship to staff managing that?
None whatsoever.
Any more discussion? All those in favor?
Aye.
Any opposed? Motion carries. I think we need a short break.
Yes.
10 minutes.
No avoiding break.
Is that it?
Now 10:30. That brings us to item number 5, appeal citation. Daniel Haas requesting appeal of citation DS-14. Alleged violation of NRS 644.30.1.
Excuse me, what number are we on?
5.
Thank you.
Is it Danielle?
It's Danielle.
I'm
It's
sorry.
spelled wrong. It's
I
okay.
apologize.
Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I would call Ms. Darlene Scott in this case, and I do have an exhibit for the record. I believe the board has already, but I thought we should admit it for the record. And so I have what you have marked as State's Exhibit 1.
So good.
And I would like to not pass it out again. You don't have it, but I wanted to make sure that everybody got a copy of it. And do you have any objections, Ms. Haas, to this being admitted? No. Okay, I believe this is all information you have. Ms. Scott, yes. She's bringing a chair.
Normally you don't sit there, that's the problem.
Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Scott, would you please state your name spell your last name for the record?
Darlene Scott, S-C-O-T-T,
And who's your employer?
State Board of Cosmetology,
And what is your job title?
Inspector 1.
And in the course of your duties of Inspector 1 for the State Board, did you become aware of the licensee in this case, Ms. Hoff?
Yes.
And how did that happen?
Upon routine inspection for the salon Distinctive Styles in Carson City.
And what date was that?
It was on October 13th, 2011.
And what did you see on that day?
I observed Danielle performing a nail extension service on an elderly female client.
And what was your concern about that service?
When I looked at her license, I saw the date had expired, and I asked her if she renewed.
What did she tell you?
She said it's in the mail.
And then what did you do?
I called the renewal office to verify with Jill, and no payments were made to her account.
Okay, and then what did you do?
Issued citation DS-14, and also I issued a citation to the establishment for $200 for allowing the licensee to work on an expired license.
Okay, and the citation to her was for working with an expired license.
Correct.
And is there anything else about this inspection that you'd like to tell the board?
That's pretty much it. She, like I said, she stated it's in the mail, and I did call and I did notify her as well as the licensee in charge that she would be cited.
You can ask questions of her if you have questions of her of what she said.
And I said that because we were in there in July. Or was in, so I was getting up. All the licenses was always been due in July, forever, and then I switched to my birthday. And that, so that's why it was an oversight on my part, and that we got the salon up and running and had all those licenses intact. And that's all.
Ms. Haas, did you have any questions for her?
No.
No questions?
No. And it's, I think, now time for the board to take questions.
Okay, I have a question. I believe our renewals are sent out, is it?
It's 9 days
Is
before.
it Ms. Scott or?
Yeah, questions of Ms. Scott.
Oh, I have Ms. Scott, thank you.
I have none.
Is Misty here, the cosmetologist in charge also? No? The
No,
Misty
she's
is local.
Well,
And now it's your time to present your case, so you can say whatever you want, and then I have a chance to question you, and the board can get to question you.
it was just an oversight on my part. I didn't know it switched to April, because my birthday is, and forever it's been July, and I wrote the letter to explain, hopefully, the salon went, the salon's fine, and I don't know, it was an oversight, and I'll pay the money. I don't know, I was just to see if I could get it reduced or, be warned.
I did have a question of you, if you're
Danielle.
Danielle. When it was due in January, or July, it was also July 1st.
I know.
And then your inspection was July 13th.
That's why
so
I made it.
It kind of still would have been.
I know, I'm bad.
Like even if you're out, even if your thing was accurate. And then I just wanted to double check, when you were licensed, did you agree to follow the laws of Chapter 644?
Yes.
Did you have any questions? I have questions. I want to make sure Sarah didn't have any questions. I believe she's.
I would be first, and I don't have questions, so go ahead.
I do have a question.
Danielle?
Yes.
Is this your correct address? Is it that, the Conti Drive?
Yes.
Did you get a notice from the state of Nevada 90 days prior that your license was going to be due?
Yes.
Thank you.
So, and you.
And in my mind, and in my book, I had it written down on my manicuring book that it was due coming up, but I didn't realize April, which total oversight and embarrassment.
Any other questions? Guess we go into a motion.
I'd like to make a motion that unfortunately we do find the respondent guilty of operating with an expired license.
I'll second.
Motion made by member Leader, seconded by member Zesiger to find the defendant guilty. Any discussion?
I'd just like to clarify my motion to include a violation of NRS 644.3/2021.
May it please the board, Madam Chairperson. Also, is there a finding whether this was the first offense, second offense, and third offense, because that will be considered in the statutory fine. So I would recommend the board to consider that,
I believe it is the first offense.
and just to make a finding of that.
Do you want to add that too?
That would be part of my amended motion to include that finding that it is a first offense. Thank you.
I'll second.
Any discussion? All those in favor? Aye. Any opposed? Motion carries. We have a motion for the penalty.
I had a question quickly of Danielle. Ms. Haas, did you already pay the establishment license fine?
Yes.
And you're both the establishment as well as the individual?
Yes.
So you have it like essentially being double fined?
whammy, yeah.
That's why you can't make that mistake. And then you realize that the establishment, now it would be a second violation. So if anybody else in the establishment were to have an expired license and the establishment is going to be hit with, could somebody clarify the fine amount for that?
It's fine. That's what I was just talking to.
Yeah. So the establishment now is kind of, you know, you
It's
want to
never
make
going to
sure.
happen again. We are on it. It's on the calendar. We have 3 sets of eyes looking for those things.
Do we have a motion?
I'll make a motion to waive the fine.
To waive the fine.
If we can have a second, then we can vote on it. Do they want to do a second to vote nay?
No. Okay, motion dies. Do we have a motion to subject fine? Uphold the fine. Or uphold it?
Yes, I'd like to make a motion to uphold the fine.
Second? I'll second. Motion made by Member Jones to uphold the fine, seconded by Member Rinaldi. Any discussion? All those in favor? Aye. Any opposed?
Nay.
So the motion carries, and you have $200.
Okay, who do I think?
You'll do that at the office.
Thank you.
Okay, that brings us to item number 8, appeal of citation. Amy Masteratis, requesting appeal of citation, alleged violation of NRS 644.290.1 and 2. Is Amy here?
Can we confirm that she was properly served to be here today and properly noticed to be present today?
Yes, she was served via certified mail and regular U.S. mail at the address on record.
So she was notified to be here
She
to
was.
be present?
Within, yes.
Thank you.
And just for the record, the mailings that you sent out were dated September 22nd, 2011, correct?
Yes, they were.
Do we want to proceed with this case? Or do we need to...
Yes, no, I believe we can. And I have, again, I believe it's the same documents you have, marked Exhibit 1 for the record, that I would ask be admitted.
So admitted.
And Ms. Bradley, if, I'm going to just call her Asteradius, I guess. If she's not present and it came to a negative result for her, she would have the opportunity to appeal our decision?
Correct.
At a subsequent
May it
meeting?
please the board, board member, yes, if you make a finding of facts that she's not here, she would receive an order. She likewise has 15 days to request a rehearing on that order, and likewise, she has 30 days to take it to the district court and say, I don't agree with it. So to answer your question, yes, she does have other alternatives
Thank
in
you.
regards to appeal.
Thank you, Mr. Ward.
You're welcome.
I would submit to the board that based on Ms. Lasso's testimony, Ms. Asteradius has been given proper legal notice of the appeal today. And again, this is something she requested. She requested to appeal the citation. This is not a case that the board is bringing against her. So I think it's a little bit different than a normal hearing. She requested that she get to appeal, and that's why this was scheduled. This was sent to her more than 30 days ago, both regular and certified mail. She's not here. Based on her failure to appear, I would ask that the board uphold this, that you find that proper legal notice has been given, and uphold the citation in her absence, giving her the fine that has been assessed in the citation, which I believe is a $200 fine.
We also assess costs.
You can always assess costs. I believe the board hasn't done that very often for citation appeals, but it's in the board's purview to do that. I'm not sure that she's been noticed in the information that she was provided that costs to be assessed, however.
Maybe she just realizes that she's guilty. It's fine.
Well, for whatever reason, we're met here because she requested it and she's not here, so I think assessing costs is appropriate.
Okay, I guess then we need a motion to,
Madam Chair, it sets a precedent that might be uncomfortable later. I mean, the bottom line is generally they contest this type of a citation because they were hoping that the board would reduce the fine. And when they don't show up, then obviously they're going to be found guilty. But my sense is you start playing additional monies, we're going to create a different kind of animal.
I would feel more comfortable if you did not assess fines, because I don't believe we've assessed costs against citation appeals. Our practice has been to assess costs against hearings, and hearings are different violations. The citations are assessed against them. They have a right to appeal it, and this is their appeal mechanism. And to charge someone additional fees because they're appealing doesn't really feel maybe as nice as it could be.
okay. Ms. Jones?
Yes, I'd like to know if this is the first violation.
I believe if you go to
You can tell by the fine structure. The fine structure indicates that it's appearing to be the first violation.
That's why I assumed, but I didn't want to assume.
Ms. Bradley, I have a question also, and I just wanted to kind of make a point of clarification for all of the board members and for the people in the audience, the public in the audience today, that this is slightly different than the last case that we heard, in that the expired license affects the establishment. In this particular instance, because it was just the license wasn't on display, that there was a courtesy call. I presume, Ms. Scott, you called the board office to confirm the valid license. It just wasn't present. And so consequently, the establishment kind of evades or avoids some type of penalty. And so I just wanted to have that clarification so we all were on the same page with why the establishment is kind of off the hook this time, if I'm not mistaken. I'd like to make a motion that the respondent is in fact guilty of violating NRS 644.290, the display of the license.
May it please the board, Madam Chairperson, I believe we should also, one, make a finding of fact that proper notice was given since she's not here, and you can include that with your motion, but I would recommend that you make a finding of fact she was given proper notice and then proceed to the next step.
Thank you. In the course of our discussion, we did notice that the respondent was in fact properly notified to be present today, and so in my motion, I'd like to just point that obvious.
I'd second that.
Motion made by Member Leader, seconded by Member Hoffman, to find Ms. Astradas guilty of the alleged violation 644.290.1 and 2.
And the second part of that motion is, and that proper legal notice has been given for her to appear today. Just so the record is clear.
Okay. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries.
Madam Chair, with all due respect, that individual was properly noticed and then found guilty in a subsequent motion or a previous motion, I'd like to then assess or uphold rather the penalty of $200.
Second. Motion made by Member Leader, seconded by Member Booth. Any discussion? All those in favor? Aye. Any opposed? Motion carries. Item number 9. Appeal citation, Caesar's Beauty World, Ronnie Bogart, alleged violation of NRS 644.320.1. Is Mr. Bogart here? Ms. Ronnie?
No action. This is name is dead.
Oh, okay.
My sister has a brain injury, so she is under guardianship at a board of court.
Are you here on her behalf
I
then?
am, yes.
Okay, please come up. Are you planning to provide testimony about the citation?
Yes.
Okay, so I think you can be sworn by the reporter. Please.
Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Let the record show that I'm showing the respondent the documents in this case marked Exhibit 1.
Actually, I sent the request for hearing, and in that I explained the brain injury of my sister and kind of why I was appealing this.
I mean, well, I guess
Is
what I'm
that
asking you, have
is
you
that
seen those,
included?
and do you have an, I believe everything should be included in there. I just want to make sure you don't have an objection to those being admitted.
No, I have no objection.
So I would ask that the documents be admitted as Exhibit 1.
So admitted.
I would call Charlene Marsh. And I believe she needs to be sworn as well.
Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Marsh, would you please state your name and spell your last name for the record?
Charlene Marsh, M-A-R-S-H,
And who is your employer?
Nevada State Board of Cosmetology,
And what is your job title?
Inspector and Office Assistant 1.
And in the course of your duties as Inspector Office Assistant 1, did you become aware of the licensee in this case, Caesar's Beauty World?
Yes.
And how did that happen?
I was on a routine inspection and went into Caesar's World.
Do you know what day that was?
It was May 27th, 2011.
Okay. And what did you see when you went in there for that inspection?
One of the licensees, David Larson, a hair designer, was working with an expired license.
And so then what did you do?
I viewed his expired license and verified with the Reno office that it had expired on April 18th, 2011.
And did you talk to Mr. Larson?
I did.
And what did he say?
He said that his license was in the mail.
And then what did you do?
I issued a citation to David Larson for an expired license, first violation for $200, and he has paid that. And I also issued a citation to Caesar's World for allowing an employee to work with an expired license, and first offense also for $200.
Thank you. I have no further questions for Ms. Marsh. It's now your turn to ask her questions about what she just said, and then the board gets to ask questions.
Does the board have any questions?
I have a question. Who is the Cosmo in charge?
Shirley Jackson.
Are either Ms. Jackson or Mr. Larson present today? Had you asked them to accompany you? No.
So you're Ms. Green?
Yes,
We let her present her
Is there no more questions for Ms. Marsh? Okay. Now, it's her turn to present your case. So you can testify, you can call witnesses, and do whatever you'd like to do. And then I get a chance to ask you questions, and then the board gets a chance to ask you questions about what you said.
I am managing the beauty salon. I am not a licensed cosmetologist. I am the sister of the owner of the salon. She has a brain injury, and therefore I manage the salon for her, and I did not realize that. I felt that it was the responsibility of all the licensees. The salon's license is current, but I did not realize that if an operator allowed their license to expire, that the salon would also be fined. I will not ever let that happen again. And I am here asking that you not please fine my sister for something that I should have known, but I thought that all the licensees were responsible for their own license, and that their failure would not come back on the salon, as the salon also had their own license.
I don't have any questions for her.
I have a question. When did you start managing this salon?
July of 08.
So it's been some time. Did you realize that if you didn't hire someone that was licensed, that you could be fined?
I did not hire any of these people. They're all independent contractors. David was there when, I don't have any idea how long he worked there before I took over for my sister. Nobody is employees. They're all independent contractors, and they rent a booth or a
But
station.
they also work under your establishment license.
Right, and I did not really fully realize that. I knew that as the establishment, we were responsible for things, but I didn't realize that I needed to go around and check everybody's licenses and make sure that they're correct.
Ms. Jones?
Yes, I'd like to make a recommendation to you on your way out this morning to stop by the office and obtain a book that will tell you all the laws, rules, and regulations.
And I'm not real sure which inspector it was that did mail me the book, so I do have that. And like I say, it will not happen again. But I really felt that as long as I was doing the part that said Caesar's Beauty World, maintaining that license and doing the things that I needed to do, the independent contractors, their license was their responsibility. And I didn't realize that the salon would be fined as well as that independent contractor.
Oh, go ahead.
Well, I just have a question. With your sister out of the picture right now, you're managing the salon. Are you being paid to do that?
Somewhat, yes.
Now, let me see, I'm not a beautician, so I'm kind of in the same boat as you. So who's in charge there? Who lets you know that there's a problem, what rules are supposed to be followed? I think you have to have a cosmetologist in charge. And does she help you and guide you?
Actually, it's anybody who happens to be there. Sometimes it's Louis, sometimes it's different people. Everyone there has been very, very good about, I just went in and said, look guys, I don't know anything about the salon, hair. You tell me what you need and how this works, and together we'll figure it out. And they've all been really, really good at that, because I'm not licensed to do hair or nails. I, of course, have my own life. I have my own things. So I'm doing what I can for my sister, but I do not intend to become licensed.
how do you know when somebody's, this is my question because I'm not a beautician. When I walk into your salon, how are you ensuring that my needs are being met?
Each one of the operators or the stylists, they are not employees. The customers are actually not customers of the salon, they're more customers of the operator. They come to see the individual, they have an appointment that they've set with an individual operator. They keep their own schedules, they've set their, so there's not, it's not like you call Caesars and ask to have your hair done. You would call the individual person and say, hey, can you fit me in?
And if somebody came to you and said, this person just applied this product and my hair's falling off, what would you do?
I don't know.
That's kind of what my concern is.
Everybody there, there's nobody that's been in the business for, gosh, any longer, or less than, I'm going to guess, 5 years. There's people there that have actually been in that salon for 25 years as a life, and they're still there. So they were able to tell me, this is what we do, this is how it works, this is, you need to keep it clean, you need to make sure there's toilet paper, paper towel. I'm kind of a qualified janitor.
Mr. Leader.
Ms. Griffith, when you agreed to manage the salon, did you agree to follow the Chapter 644 of the law?
No, there was not really a mention of that. When I did this for my sister, she was in coma. So it was basically through the guardianship court. She has a separate guardian. Actually, she has 2 guardians. And they knew less about beauty salon than I did, which is the reason why I said, yes, I'll go ahead and take care of that.
Now that you've received the law from Ms. Marsh, did you send that to her? Do you agree to follow the Chapter 644 of the state law?
I do have a question, Ms. Griffith. I noticed too that on the during the inspection, there was other violations found. And some of them, I mean, this has to do with everything that you've agreed to take over and do. And you do not have to be a cosmetologist to own a salon, but you do need to know the laws. And you've had, since 08, you said, to come up to speed. And I'm having a little bit of a problem with that. That there's been this amount of time, and that you've had cosmetologists that, like you said yourself, that have not been in that salon less than 5 years, that all know how to follow this. I just have a little bit of problem with the other violations on top of this.
May I ask a question of someone else in the room? I know I said I didn't have any witnesses and I didn't have any questions, but is that okay for me to do that now?
May it please the board, Madam Chairperson, is she calling a witness? Is that what technically
No, I
she's
just had a question of someone who's present in the room.
I would say that would be calling a witness, so you would want to put them under oath if you're going to ask them.
She's already been, actually,
One of the other.
am I doing okay? No, I'm asking you, because they're asking if I'm trying, and I'm asking the inspector that I met last Monday, who we went through things together, and I took the time to make sure to be there for that inspection. You set an inspection time. I do not work in the salon, so generally when they come in to inspect, I'm not there. I do know of anything afterwards, and I do go to great lengths to take care of all things that are noted on the form. And I think that Ms. Scott, she actually met me last Monday, so maybe, I don't know, I feel like I'm doing a good job, but maybe she could better answer that for me.
With all due respect, Ms. Griffith, your report of your salon establishment tells you what to do.
Yeah, I
mean, it's quite clear. Remove the hair after each client, and then clean those petty spot screens, and then also do whatever this one is. Like, that's a big one. So I mean, you don't need to have somebody advise you of that. It's very quite clear.
Okay. I do actually go in and do those pedicure chairs. I do them myself weekly, and the operators are supposed to do them according to your law. It is posted on the pedicure chairs, but I do make sure to do a weekly cleaning, which is usually on top of their weekly cleaning, but that way I'm sure that it gets done. Because like I say, I am not there all the time. And they have the ability to make their own hours, so, I mean, they don't work at night, but they can work 16 hours during the day. Sometimes that salon is open.
And you've also put your trust into these people to run that salon while you're not there.
Yes, well, actually, that was my sister's trust. You know, these people were people that she worked with for many, many years.
Is there any more questions?
Madam
Mr.
Chair,
Janelle.
I'm having a concern that she doesn't quite understand the questions you're asking. What they're trying to ask you of is it's not just a floor space you're renting 150 square feet. The law requires you to name a person who's qualified licensee to be in charge of anybody that's in there at all times.
Right.
And so that person would be required to make sure the licenses are in place, that each of the operators are doing the things they're supposed to be doing, and that they are complying with all the laws of the Chapter 644. When you're not there, do you appoint a person who's the person in charge?
No.
Okay, I think that's the question they were really trying to ask.
Okay. As a manager and an owner of a salon, I cannot trust, and maybe that's not the right word to use, but for every manicurist to clean out that petty spot, or every hairdresser to take the hair out of the bowl, or to make sure that the towels are all kept in a closet. I have to be sure. I have to watch that.
Yes. Yes.
So, I guess what I'm trying to say is, it's maybe you need to change your mode of operation.
Oh, every time I go in the salon, the first thing I do is I go to all the shampoo bowls and I pull it, because we have the little strainers. I not only do I check the little strainer, I pull the strainer thing out. I make sure. There are about 50 water fixtures in that building, so I do try to make very, very sure that there's nothing in any of those drains, because that could really, that's a lot of water fixtures. And luckily, we have not had any plumbing issues at all. We've had a couple of things that have leaked, but as far as any kind of a stoppage or anything, we have not. And that's even just as a person who knows that things go down the drain, that drain is very important. And if there's hair in there, it's a big deal for stopping it.
You're not understanding what the hair in the
I understand that
drain-
it's unsanitary. I understand that.
Okay, but now you say that when you go into the salon, that's the first thing that you do. You need to make sure that whoever's in charge is doing the same thing, because that hair could be in there all day long. And then if an inspector walks in, you're going to get cited for that again. And you haven't been cited for it. It's kind of a warning at this point, but that's just kind of adding to the fact that you'd have a person in there that did not have a current license. And that's, I think, where I'm at.
You know what I'm hearing is kind of like somebody that bought a restaurant that doesn't know how to cook. And that's a little bit concerning to me sitting on this side of the fence. So I think basically what we're trying to ask you, how are you going to inform yourself so you can learn to cook, or how you can learn to...
That's why I asked Ms. Scott if she feels that I'm...
But if Ms. Scott isn't here...
No, I'm just saying...
How are you going... What steps would you be taking to inform yourself and learn to cook and learn to run a beauty shop? What steps are you going to take?
I do personally do a lot. Like I say, I do personally clean all three of the petty spas on a weekly basis, and I know it's on top of the manicurist that are supposed to be doing that.
Let me ask the
But
question
in
this
the
way.
event that that is not done, I'm making sure that I do it, and then I do have,
What if I come into your salon and your operator puts product on my hair and it immediately starts to fall off? What would you be doing about that? Those are the questions that I would expect you to answer for.
we do have a malpractice insurance policy that is, it's maintained. There are every one of the operators does maintain their licenses, they maintain their continuing education.
Not quite.
Okay, I think basically you've heard enough. I think we need to go into a motion.
Unless she has more testimony, do you have anything else you want to tell the board?
Okay. Do I have a motion?
I'd like to make a motion that the respondent is in fact guilty of violating NRS 644.320.1, allowing Mr. Larson to operate on an expired license.
I second. Motion made by member Leader, seconded by member Zeziger. Is there any discussion?
I have something. I'm just concerned that more than somebody not being licensed there, that there's nobody managing the salon by her own testimony.
It's not really under our.
Well, it's perfectly allowable to have an unlicensed owner of a salon.
I understand that.
And that, in fact, I think from her testimony, she's indicated that she's developing a better system for having the cosmetologist in charge. It may not be an adequate system for us today, but it sounded as if, as a manager of the salon, that she was taking steps to it.
And that's my concern, is not just that this wasn't done, is that those steps are taken and they're followed through.
There will be further inspection.
Citation is what's before.
Okay.
Any other discussion? Ms. Jones?
I'd like to make a recommendation that
We've
if
got a
you
motion
don't-
on the table.
Oh, excuse me.
I don't know if we can make a recommendation.
Correct, it's discussion only, no recommendations unless it was a friendly amendment of that nature. Because before the board is the violation, which is upon for discussion before the board.
All right, then I'll take that as, all those in favor?
Aye.
Any opposed? Motion carries. Now we go to recommendation, correct? Did she recommend something?
Yes.
Before we go into the penalty?
Yes, as a former salon owner myself, I'm not sure what you have in place at your salon, but you may consider contracts for the people who are renting spaces and what your expectation in the law requires, so that you have something that they're accountable to you directly for.
Is there a place that I would go to for like a standard contract?
I'm sure there's many online you can look for, standard contracts.
A good attorney.
Yeah,
Mr.
good
Chairman?
attorney.
I'd like to make a motion that we uphold the fine.
Okay, just, Mr. Jim Brown?
Yeah, before you make your motion, Mr. Leader.
Okay.
Apologize. The issue really that you're having a hard time understanding is if you have a medical facility and their requirement is to have a full doctor in charge of the medical facility on a given day, that's not what's occurring. You allow the operators who you trust to sort of whoever's around do it. That's not acceptable to the board. You have to actually have a person who's named as the lead and is fully responsible for all the activities of that building at all times, whenever there's someone touching someone else. So that's the issue that they're struggling with. And you need to take a serious look about it. You can't be there all day long, that you have a system which names Sally Smith or John Jones to be the cosmetologist who's in charge. And there's regulations as to who can be in charge, that Ms. Scott and Ms. All the inspectors will tell you for that matter. Charlene or any of them will say if you're doing nail technology, you got to have someone who's qualified to make sure the nail technology being done is safe and proper. So that's the real issue they're struggling with. They realize you're doing God's work, I guess you could call it, in helping your sister. But that means that you become liable for the failure of the system to not meet the standards of the code. And that's the real issue that they're dealing with here. I apologize
I would like to make just a little statement that as far as, actually, I'm going to retract that and I'm going to hold that. I'll let you go.
And this is no offense, Mr. Jimno, but I actually feel that the real issue is how do you have a cosmetologist in charge who's an independent contractor when you're asking to make specific demands of them? If you're asking them to be present, I find that the independent contractor status of a cosmetologist in charge is very suspicious. So that's a separate matter. I have a motion on the table prior to the discussion that the fine be upheld.
Is there a second?
A second.
Motion made by Member Leader to uphold the fine, seconded by Member Hoffman. Any discussion?
Can I just make a statement?
Go ahead. Discussion?
Yeah.
Is it discussion?
No.
All those in favor?
Aye.
Any opposed? Motion carries. I would like to say that maybe you would talk to Mr. Larson.
He's no longer in this law.
Would you like to say?
Yes. You might also check with the state what their laws are for independent contractors, and also with the IRS, which may sound a little strange, but when I did my salon, I went through both of those and I got a lot of information. And so the state and the IRS consider independent contractors different.
And Ms. Griffiths, I would like to also say that we're here to help you. Do not hesitate to call and ask if you have a question about something. Anybody in either one of our offices will be more than happy to help you. If you're not quite sure about something or you don't understand the law in the book, that's what we're here for. Okay?
Independent contractors does not mean they get to do anything and everything they
No.
want. No,
That's it. Yes, thank you very much. Okay, that brings us to item 10. Appeal of citation, Radiant Salon and Day Spa. Shannon Daniels requesting appeal of citation CM-132. Alleged violation NRS 644.320.1. Approach.
solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth.
Yes, I do. Shannon Daniels.
I'm showing you what's been pre-marked as State Exhibit 1 in this case. I think you've seen all these documents. Do you have any objection to those being admitted? No. So for the record, the documents that the board has should be admitted as State Exhibit 1.
So admitted.
Ms. Marsh, in the course of your duties as field inspector for the state board, did you become aware of the licensee in this case?
I did. I was on a routine inspection on July 14th, 2011.
And what did you see when you did that inspection?
There were people working with expired licenses.
When you say people, that's more than one?
It was, one had extenuating circumstances, shooting a customer Coleman, and that was voided, CM-130. CM-131 was issued to Janine Jones, and she has agreed to pay the fine and sent notice to the board as such last Friday. And also, this is a second citation for Radiant Salon. I also issued one CM-52 in October of 2007. So it's a $500 fine, second offense.
Is the previous offense the same?
Yes.
Okay. And so when you went into the salon, you saw people working without a license, and what did you do?
I always called the Reno office, which I did that day, to verify that the licenses were expired. For Janine Jones, it had expired, and did verify that it wasn't in payment pending or anything, and issued the citation for that.
And did you talk with Ms. Jones?
I did, and she had said that it was in the mail.
And what else did you do? Issued the citation. Was there anything else that you noted?
I did, there was a second citation, Sheila McCusker Coleman, that was also expired, and she did have a copy of her money order that she showed me, but it still was not in the Reno office, and I did verify that, so I issued a citation to her as well.
But then that one was later voided, I think?
Yes, it was.
I have no further questions for Ms. Marsh. It's now your time to ask questions to her about what she said.
I don't have any questions, but I want to apologize how Janine treated you when you were in the salon. She also no longer works with us.
Sorry. Thank you very much.
Ms. Marsh, just as a clarification, it's, even though there's two individuals that had expired license, it's really only one citation. The fact that it's a second citation is merely that there was another one issued a couple of years ago.
Yes.
And then, in fact, the establishment license was also out of date, but you did not issue a fine for that. You just gave her a warning and said to renew it. 5-day. It says a 5-day compliance or a citation and fine will be issued.
Yes.
So even though the operators, then there were two, were operating without unexpired licenses, this salon was also operating with an expired license, which was not cited.
No.
Thank you.
Does anyone have any other questions? Ms. Marsh? Yes, then. Turn it over to Daniels. Is it Daniels? Ms. Daniels?
I understand how all this has changed when everybody's now there to school my birthdays. My birthday was May 28th. It notes in my letter that I actually had spoke with Janine at the beginning of May. I had already talked to Sheila about her situation. She said it had been 45 to, I don't know how long, February I think is when she first started proceeding to get her license. So I knew what was going on with Sheila. Janine, at the beginning of May, had asked me specifically about the online test that we have to take. And she asked me, was it difficult? How long did it take? I said, it's actually real simple. You listen to the video, you take notes if you need to, and you answer your questions, and you're done. So that's when she had told me that she was planning on taking the test that night. I had taken it the previous week. She told me that she was going to mail in her license that following week, and apparently never did so. And I specifically had asked her after Ms. Marsh had come in, I thought you had told me that you were handling this in May. So I'm not trying to take no responsibility for the situation because it is my place to make sure that these girls have done what they've done. A couple things that I've done differently now is I have 29 girls working there, so we now have done a schedule with a calendar that tells you when everybody's birthday comes up on what month so that I can keep an eye on that. One suggestion that I have for anybody else that's going through this situation is if somebody's telling you that they did something, you can't necessarily take their word for it. So if you need to call and check, that's what you have to do.
Or you can look at their license.
Well, yeah, but some of them will say, oh, I nailed it in. Oh, I'm going to do it this week. And then they don't do it because I know it's been, like with Sheila, it took, I don't even know how many months before she finally got her license.
But there would have been a record that she had paid it.
Right, she would have had...
I mean, if you had contacted the office, they would have said, yes, it's in the process.
Well, that's kind of what I'm thinking, that at this point when somebody has not renewed their license on time, and I've spotted it, that it's not renewed, that I think what I need to do, if they tell me that they have mailed the check in or whatever,
that I need to take it upon my responsibility once in a while to call and double check with you guys.
Or send them home, perhaps, because then it would actually happen timely.
Right.
Like you wouldn't have that as an issue if your policy was pretty heavy-handed.
I agree with that. The one thing that I have concerned about with the girls that have recently renewed their licenses, it has been taking quite a while to get it back. And I don't know if it's, I know they switched something around to where Reno was taking care of Reno, Vegas was taking care of Vegas, and now they switched it back to where Vegas is taking care of all of them. I don't know. It's confusing to all of us, but I know a lot of the girls they've had to wait quite a while to get their licenses back.
That's something that would be addressed. But Ms. Bradley, did you have a question?
Well, the only question I have of Ms. Daniels, I have two questions. So it sounds like you're not contesting that Ms. Jones's license was not current.
No, absolutely not.
And then it also sounds like you're not contesting the fact that the salon's license was not current.
Correct.
But that was not cited, so you were just cited for the one violation.
Right.
Thank you.
I have a question for you, if I may. Was the employee that was cited terminated because of?
No. She was, first of all, she's not an employee. She's
Right, I'm sorry,
independent
the independent contractor.
Right. I had typed this letter up and was on my way down here to drop it off. Had no problem with her reading it. Sheila had wrote a letter to you guys and Janine both. They both gave me copies. I gave a copy to Janine explaining to her what I was doing. She had already tried to write a letter defending herself, and I was writing the letter not necessarily to defend myself, but to hopefully ask for the reduction of the fine. In the meantime, as I was leaving State Board after I had dropped off the letter, she took it upon herself to get at my front desk in front of clients and in front of other girls that work there and my receptionist, continuing to cuss at me on the phone as I'm driving down the freeway, telling me that I just shoved her under the bus. And I said, well, it is what it is. I'm not going to defend that you didn't renew your license on time. So anyway, she continued to do this at the front desk. I calmed down. It took me about an hour. I went back down to the salon. Had one of my front desk girls walk up to her quietly and tell her that I was there and that I would like to speak with her for a minute. And she specifically told me that she's got too much on her plate, that she doesn't have time to talk to me. So I left, had to go get my kids. Figured that maybe when she got off work.
Ultimately, she's no longer there.
Right.
I have a question. Why do you think we should not fine you?
Well, I don't think that I should not be fined. I agree with the fine completely. I would rather not ever have a second fine. The first one was a big enough mistake right there. The part that I was trying to let you guys know is that somebody had told me that they were handling it and that it was being handled, and it wasn't. And like I said, I think one way of being able to make sure is if somebody tells you that, then you call and find out, just like you would do. So, not saying that I was in the wrong, because it was definitely my place to make sure it was taken care of.
Thank you.
Ms. Daniels, it sounds to me like you have every intention of following Chapter 644 of the Nevada law.
Absolutely.
Thank you.
I think the changes that I've made also with the calendar will help tremendously.
I wish you would have done that in 2007.
Well, you're right, it hadn't changed the birthday thing now is what's, trying to keep up with 29 of them.
I would like to state also that you look at your inspection sheet, and I will address and make sure that these things that have been marked off, they can be taken care of. And also, they will be changing the license dating of your establishment license, and you need to be aware of that.
They're changing that too?
Yes.
And is that all?
That you'll be notified on, I believe it's on the date you open.
Yeah, the new law allows from the date of the original issue, then it's on that date thereafter.
Okay. And that'll start this next year then?
You'll be notified.
Right.
You'll be notified, but it's legal now.
Okay.
as they come up for renewal.
Well, obviously, I just renewed that, so
Yeah,
next
your renewal is the same, but it'll basically only change for the new, as they open new or change hands.
Okay.
And then it'll establish the date that.
I'd like to make a motion that, in fact, the respondent is guilty of violating NRS 644.320.1, allowing two individuals to operate with expired licenses.
Second. Motion made by Member Leader, seconded by Member Booth. Any discussion?
May I please the board, Madam Chairperson? In this motion, was it for a first offense or second offense? I think that should be clarified.
It appears, thank you, Mr. Ward, and I'll amend my motion to include that it appears that it is a second offense.
Second.
Any discussion? All those in favor? Aye. Any opposed? Motion carries.
I make a motion that we hold the fine of $500 for the second offense.
A second.
Motion made by Member Booth, seconded by Member Seziger. Any discussion? All those in favor? Aye. Any opposed? Motion carries. Continue.
Can you look at the order now?
Item number 11, Nevada State Board of Cosmetology versus Crystal Nails, Cindy Ho, owner, for alleged pattern of repeated violations of the NRS 644.190 and NRS 644.360.2. Is Cindy Ho here?
Well, in Ms. Ho's absence then, I would like to ask that exhibits marked 1 through 3 be admitted.
Do we need to bring forward that she was posted?
We'll do that after, because the proof of mailing is in the exhibit.
Okay.
But I believe since she's not here to object to the admission of the exhibits, it would be inappropriate to look at them.
Ms. Bradley, while you're passing these out, are we allowed to ask a question, or do you need to present first?
Depends on what you're going to ask.
Well, I always find it interesting that when, like in the allegation, it says unlicensed capacity herself, but in the petitioner respondent section, it indicates that she has a license.
The establishment is licensed. The owner of the salon is not licensed.
Thank you.
Does everybody have exhibit 2? For some reason I have an extra. So hopefully everybody has exhibits 1 through 3. If you turn to the back pages of exhibit 1, you can see that the complaint and notice of hearing in this matter was sent to Ms. Ho at both the business address and her personal address.
Ms. Bradley, do we need to present evidence?
I believe you've already admitted them, but if you haven't, yes.
I did not admit.
Okay, exhibits
So
1
I'd
through 3 should, I'm asking they be admitted.
So admitted.
And if you look at the page 6 of Exhibit 1, as well as the following pages that show the mailing envelopes, I would submit that we have achieved proper legal service in this matter, in that the complaint and notice of hearing, noticing Ms. Ho for the hearing today, was mailed to her on the 23rd of September, and it was sent to her personal address and her business address. It was sent via regular and certified mail. So, as you can see, the 2 certified mails did come back. One was unclaimed, which means that it sat at the post office for a specified period of time and they returned it. The regular mail one, we believe, was received and has not been returned. And then the other one was returned because there was an issue, I guess, with there's no mail receptacle. It looks like the mail person did try to actually walk in the door and deliver it, but was unable to. So, but we still believe that we have achieved proper legal service, so I would ask that the board move to decide the matter in Ms. Ho's absence pursuant to NRS 622A.
I'd like to make a motion that it appears that the individual, the respondent, Ms. Ho, was properly notified or attempted to be properly notified.
I second.
Motion made by Member Leader, seconded by Member Hoffman. Any discussion?
And I'd like to amend my motion to include that we proceed with this complaint and notice of hearing.
I second.
Any discussion? All those in favor?
Aye.
Any opposed? Motion carries.
And before I call my first witness, I would like to just let the board know, with a brief opening here, that what we're hearing today is we're here on a pattern of unlicensed activity. We're here because the establishment, Crystal Nails and Spa, has had more than one citation for unlicensed activity, and pursuant to NAC 644-700, the board has asked that all second and subsequent violations of unlicensed activity come before the board. So there are citations at issue, and we're not really here to determine the facts of those citations, whether or not they happen, but we're here to determine whether there's been a pattern of unlicensed activity such that the board should consider further disciplinary action to the establishment. And I would like to call Ms. Scott as my witness. Ms. Scott, as inspector for the Nevada State Board of Cosmetology, did you become aware of the licensee in this case, Crystal Nails and Spa, owned by Cindy Ho?
Yes.
And how did that happen?
An anonymous call came in from another salon in Pine Village stating that there was a Crystal Nails and Spa that was open, and they were thinking that it was unlicensed
Okay.
establishment.
Okay, and so it seems like you've done at least 2 inspections of the salon?
Yes.
Okay, can you please walk the board through the 2 inspections that relate to the complaint in the instant case? And I think the first inspection was dated May 6, 2011.
May 6th was a compliance inspection. It wasn't the first inspection.
Okay.
But upon entry, Ms. Marsh and I stated who we were and our purpose for being there. The lady performing the services at the right, first station to the right. When I asked if she had a license, because I didn't see one posted, she said no, and she proceeded with her service.
Okay. And so what did you do next?
Proceeded with the inspection and notified the Cosmo in charge that we would be issuing a citation for unlicensed activity and that we needed ID.
And that cosmetologist in charge, that was Tammy Wood?
Tammy Wood, yes.
Okay. And did you find out who was doing the unlicensed service?
Yes.
And who was that?
Cindy Ho.
And she's the owner of the salon?
Yes.
Okay. And so did you cite Ms. Ho personally and as a salon then?
Yes.
For that violation? And did you prepare a report regarding this inspection?
Yes.
And was that report prepared in the ordinary course of business and as part of your duties as inspector for the Board of Cosmetology?
Yes.
And this report is maintained in the licensee's file as part of the board's business records?
Yes.
Okay. And now let's talk about the June 30th, 2011 inspection. What can you tell us about that inspection?
That was a routine inspection, and upon entry, I stated who I was and the purpose for my visit. Immediately, a young lady who was polishing another lady's toes at the last pedicure station. She stood and faced me, and then she left the salon through the rear door and didn't return.
And was this second inspection, this was as a result of that phone call that you received, that something was happening?
The second inspection? No, it was just routine.
Just a routine inspection, okay. Okay. So you saw someone leave the salon?
Yes.
And so then what did you do?
I asked Tammy Wynn who the lady was and if she was licensed, because I didn't see a license posted, and she stated that it was her niece, and she would be applying for a license.
Okay, and did she give you the person's name?
No.
And so we didn't learn the identity of the unlicensed person. So in this case, did you issue a citation?
Yes.
And that was just to the salon?
To Crystal Nails, yes.
And did you prepare a report regarding this inspection?
Yes.
And that report was prepared in the ordinary course of business and as part of your duties as an inspector?
Yes.
And this report is maintained in the licensee's file?
Yes.
Is there anything else that you'd like to tell us about these citations or inspections?
The only other, with the second inspection, Tammy really tried to bribe me and convince me that, you know, no one had to know. And she kept calling the girl, but she never returned to the salon. So I left after completing the inspection.
With all due respect, Ms. Scott, she didn't return to the salon while you were present.
Right.
She may have very well returned to the salon once you left.
Yeah, she could have.
The second thing is when you asked the person if they had a license, and you said that she proceeded to do the service, what is the protocol for you to protect the public when somebody says, no, I'm not licensed? Do you have them stop?
Well, I went in the rear of the salon, and Charlene called Tammy to come in the back and let her know that we would need to get Cindy away from the client. And we spoke with her and told her that she needed to see Cindy Sis.
When you said bribe, did she offer you money or anything like that?
She offered me free services.
So she did in essence, yes.
Yes.
These fines that were put here, are they paid?
The salon, let's see, there were a couple of them that were paid.
There's
The last citation issued was paid,
the $1,500.
the $1,500, and there was another $1,000 fine that was paid.
So she pays and but continues to do what she...
Yes, there is one that's outstanding
Is that the first one?
for Cindy.
Oh, so the individual citation has not been paid, but the salon's citation has been paid.
Yes.
And she couldn't renew her license probably, but she didn't pay him. She didn't need to renew her own because she doesn't have one.
And has this person been before us before? The name seems so familiar.
Before the board?
The Tammy, this one here, the Tammy. Oh, is that how you say it? Wynn?
Wynn.
Okay.
I don't think she's been before the board. The case has been, it's been going on for a little while.
They might have come up with it
Madam Chair, Ms. Jimno, Executive Director. Wynn is a common name in Nevada, very common name.
Okay.
So you've probably seen that name 50 times since you've been on the board. But this particular person has not appeared before the board. They've paid the fines, avoided us in the meantime.
It seems too that Tammy Wynn has been cosmetologist in charge for both citations.
Yes.
Does the board have any further questions for Ms. Scott?
No.
Well, based on Ms. Scott's testimony and based on Ms. Ho's failure to appear to contest the violations, I would ask that the board find that all of the factual violations in the complaint are true. That would be facts 1 through 16, violations of law have also been proven and are true. I would note that in the first claim for relief, there's been 2 counts of allowing an unlicensed person to work and 1 count of actually doing the unlicensed activity as the owner. And so that is noted in both the first and the second that there's actually 2 counts of this repeated practice. Well, 2 counts of it occurring constitute a repeated practice is what I'm trying to say. So I would ask that the board find that everything is true in this case, to find that she did make a violation.
Another question, please.
Ms. Scott, did you say that you looked at the ID of Ms. Hope?
Yes.
And did you at all assess whether the address on her ID was either one of the addresses that were attempted for certified mail?
Yes. The
And
Antelope.
would you just recall? Do you recall which address that was on her ID? Was it the Antelope, California, or the
Antelope,
Pine Village, Nevada one?
No, it's the Antelope. On her ID. It's a California ID.
California ID.
I believe it may be noted in the inspection, so that would be in Exhibit 2. I believe there's a place we can note the address.
So in other words, you made every attempt. You confirmed the address, you looked on the file in the system, and then you had another address for the establishment. So I mean, basically, there were 3 available addresses to you. You picked all 3 to mail.
The 930 Tahoe Boulevard, that's the, in Pine Village, that's the license of the establishment. And so that, we did send it there, regular and certified, and then we also sent her personal address, which is in Antelope, California.
I have one question. On the main, or let's see what we do, on the main issue of, or findings that when you got your computer printout, that you did the first one that was done on 6:30, it says, there's a form here that says, it says, I do not contest any of the following allegations, and they signed it. The second one that was done in May, it doesn't have that form attached. Is that come at a different time, or, I mean, because she says here, I do not contest the following allegations. Okay. So, this is citation, and this paperwork here comes from the office. Okay, I just, because she didn't have it on here, so I was just, thank you.
We need a motion.
Yes, to find the guilt.
I'd like to then make the motion that the respondent, who may not be present but was in fact notified, or every attempt was to notify the respondent timely, is in fact guilty of the factual allegations 1 through 16 as presented.
I'll second that motion. Motion made by Member Leader, seconded by Member Benaldi. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries.
I'd like to second motion that the respondent is in fact violating the law in her first claim, violating NRS 644.362 and or NRS 644.190, number 2.
Second.
Motion made by Member Leader, seconded by Member Hoffman. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries.
I'd make that third motion that the respondent, having first been found guilty of factual allegations 1 through 16 and her first claim for relief violation of the law, she's in fact guilty of violating NRS 644.4301K.
I second.
On page 3.
Motion made by Member Leader, seconded by Member Hoffman. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries.
And I do have a recommendation for discipline if the board is ready to hear that. that means is the person cannot reapply until the expiration of that period. Doesn't mean the person will be relicensed at that time. But it's up to the board. But I guess I would recommend on the lower end of 1 year or 2 years for that revocation period. And I would also ask that the board assess costs against the respondent not to exceed $1,000.
Mr. Ward, I had a question on the board responsibility for the revocation of an establishment license. Is that correct? Is there some responsibility that we have if, in fact, there's some type of lease for that establishment to be in some type of business center, and that if we take away that establishment license, somehow we're interfering with the day-to-day business of a potential lease obligation that that owner might have or that establishment might have?
Please, the board, Madam Chairperson, board member. The board, as you well know, is established to protect the public. If you're worried about what kind of liability you may have for shutting someone down and their employees, I think as long as you follow the law, which apparently you're in the process of doing, and have properly revoked the license, I don't think that is a concern to the board, if that is your question. Are you asking?
I'm asking if we would be interfering with that establishment's lease or business responsibilities to someone else, because it appears to me like they're in a mall.
Well, I mean, I would argue, if you want some legal argument on that, you can't avoid disciplinary action by saying, oh, I have a lease with somebody, so you can't revoke me, because that would be contractual interference. I mean, that's not a legal argument that could stand. By revoking the person, there is still an opportunity for the person to have someone else take over the establishment. So it may be closed just for a small time period, and a new owner might step up and take over in that same spot. But I mean, I guess I just think, interfering with the contract regarding the lease would be, there's just no way. You can't say, I've got a lease, and so you can't revoke me.
I was under the impression that we were discussing the revocation of an establishment, not just a revocation of an individual.
You're discussing the revocation of an establishment license, so you'd be closing down the shop, which is fully.
But that doesn't mean somebody else could take it over.
Yeah, they could.
Somebody else
It could
will
be
come
sold.
and relicense.
Mr. Jimno?
Yeah, Vince Jimno, Executive Director, to the Chair. What it would mean is they could sell it, they could relicense it, but that person who owns it cannot.
Okay.
Can we also add her name in there because this is Crystal Nails, am I correct? And add Cindy Ho in that
I believe
motion?
the license is titled Cindy Ho, owner, doing business as Crystal Nails and Spa. So if you revoke Cindy Ho doing business as Crystal Nails, it would revoke her. She can't reapply in this capacity, but I think, there could be possibilities of similar names, but I suppose if the Social Security number is noted in the file, or there's some other identification, you can be sure that she's tracked appropriately.
I have a question too. On the fines, again, we can fine $2,000 per citation, and that would have to be paid prior to her ever being able to get her license back in a year.
Yes. So, I mean, you could do that. In previous cases similar to this one, you have not done that, though. You have revoked people. You have not fined them. You've also suspended them for a certain time period, but I'm not aware of you revoking someone and fining them.
Ms. Jones?
Yes, we had discussed in the past adding education to the penalty phase, as people are very easily gone to the counter to pay out their fine and then re-establish themselves and do the same thing again and again and again. I would like to visit perhaps taking so many hours of state board laws, rules, and regs. If this person repeatedly breaks the law, then maybe she needs to be educated in addition to any fines.
Well, but if you're going to revoke her license, then adding education would be maybe not appropriate.
As a term to you.
Well, certainly once she's been revoked, if she were to reapply, I think that the board can automatically. I was actually talking to Mr. Jimno about this. I think it can be. I think it's in good practice that if someone has been revoked by the board, if they reapply, staff automatically denies them, and they come before the board before they can be relicensed.
And that's an administrative policy or
Yeah,
an administrative practice.
because currently applications are reviewed by staff, and staff approves all the routine ones. And I I think it's my position that if you've been revoked by the board, you're no longer a routine application. Now, I'm not saying you can never be relicensed, because that's against the law. But what I am saying is if you've been revoked and that's in your file and you reapply, that you'd be denied, and then you'd have to go before the board to request a license. And then in that case, the board could add requirements for relicensure based on the past discipline. So,
I have a question of our staff here. If we assess that person $2,000 and we haven't done it in the past, is that going to cause a problem for us?
May it please the board, Madam Chairperson. No, I don't. Yes and no. It's a typical attorney answer. Are you setting precedent? Yes. But are you establishing your goal? Basically, I think what you're trying to say is, will she have to pay this before she can ever get her license back within that year, or after that year's lapse? She's got to pay this. That would establish your goal. So if that's your goal, so be it.
Thank you.
I mean, my only concern is if you revoke a license, a person can't work, so it's hard to find someone when they're not able to work. You can increase the revocation period. I was just suggesting 1 year because, we have the 2 violations, which really are 3 because the one was sort of twofold. And I know in previous cases, I believe you did a 1-year revocation for a similar case. So
You know what, though? I think that I don't feel like we should be going easy on the person because it takes her livelihood away, because what has she done to the public in the meantime? I mean, if you name somebody for the rest of their life, 1 year isn't that much.
it's up to you. I mean, I guess to me, a revocation is the stiffest penalty. So, when I'm looking at a revocation between 1 and 10 years, it's totally up to the board. You can do 10 years if you want.
We can revoke the license for a period of 1 year, but also state the fact that if they reapply, they have to come before the board first.
Yeah, and you can also increase the period to 3 years, 5 years. You could fine her. I am asking that cost not to exceed $1,000 RSS.
And this person is actually not licensed anyway, so we wouldn't be taking away her livelihood.
Well, her establishment license, which is
Right, exactly.
assuming she
But
gets
if
money
we-
from owning the
If we
establishment.
add, a penalty in addition to the revocation, she's not going to be making a living doing nails anyway, or she shouldn't be because she's not licensed. So
Well-
she needs to find a new line of work anyhow.
I mean, that's if you close the salon, yes. I mean, she's going to have to. If you leave the salon open and you fine her, then she's going to pay the fine out of the money she receives in the salon. So it's whatever you think is appropriate.
And then, Ms. Bradley, just as a point of clarification, this would be a 45-day onset from the date of her order?
I
Roughly.
think that would be appropriate. But I think this case is distinguishable from the other one because we clearly did send information to the salon. So I don't know.
In 2 separate addresses to try to.
Yeah, I mean, this was the information we had. So I'm not sure that this one needs to, normally there is an effective date of the order because you give a person time to receive it. And so the standard language in my order says this order is effective upon receipt or upon the green card, the receipt, which is the date the green card says, or 15 days, because sometimes people don't sign for the certified mail and I still need the date. So that's my standard language. I think you can revoke the license effective, when the order's received. Usually a revocation, especially something like this when you're closing a salon, is effective immediately. And if the person wants to appeal, the person can appeal, and then they file a stay at that time. They file a motion for stay, so they can request that the board order be stayed while the appeal is going on. But there's a mechanism for them to do it. The other case was a little different in that the zip code may have been transposed, and so there was some question about did he get an actual copy in his hand. We wanted to make sure, and we don't think the person's actively working anyway in Nevada. So I think they're distinguishable. I don't know. Legal counsel maybe can give you better advice, but I'm not sure you have to wait.
May it please the board, Madam Chairperson, I agree. There's no requirement in the statute that makes you say, all right, upon receipt, you give additional 30 days to close out their business. As per the statute, you can revoke, and as counsel said, it will be put in the order upon receipt and or 15 days to cover everything. Your revocation is on this date upon receipt. So I don't think there is a nutshell, there's nothing in the statute that would prevent from what Ms. Bradley is saying in regards to revocation.
And so if the person was objecting to it, what they would do is they would say, oh, I have this order in my hand. Uh-oh, I better call a lawyer, and I better get a petition filed tomorrow and a motion for stay filed at the same time to stay this revocation. And if they don't file a motion for stay in a timely manner, it's not staying even while it's pending. And the appeal process. Joe?
Yes, is there a public notification by posting outside the establishment door as similar as a foreclosure that notifies the public that the establishment is no longer functioning, so they do not enter and continue to be served?
That's a question for staff. I mean, the order is public. It can be given to anyone. I don't know that it's not inappropriate to put it on the outside. The question is, you don't want to confuse someone, though, because if this person is revoked at that place, it doesn't mean that I can't buy the salon and go to that place and have a valid license. So
There's
you don't
still
want
a
to be
timeline between the time it's closed and then it's reopened.
Yeah. So you don't want to be confusing is all I'm thinking of a new person.
Okay, do I have a motion?
Oh, well, it's not. I suspect I can be responsible for this motion then. The respondent, having been found guilty of her factual allegations and her two claims were relayed, first and second, and I would then enter the penalty phase with my motion by taking the Attorney General's advice, Assistant Attorney General's advice, or DAG, for the revocation of a period of not more than 1 year to be effective from the date that the order is received, or 15 days from the date that the order is mailed, and that costs be assessed but not to exceed $1,000. And you had, and that the fine structure be upheld.
Well, no, 2,000 per.
It's 2,000.
2,000 per violation.
And so just uphold the $2,000 fine per violation.
You're assessing.
Thank you.
That's the max fine. So
Not upholding it, but
anything
assessing. Thank you.
between 0 and 2,000 per violation.
And do we need to say in there that it has to be paid prior to her obtaining another?
Yeah, I mean, I think you want to give a time period again, because the risk, in my mind, as your legal advisor, is always once you are revoking someone's license, they may never come back to the board again. And so I think you need to have a time period of you need to pay the fine within such and such a time period, or else we're going to try to collect it. Because if if you're revoking them, they don't have a license. I mean, when someone is licensed and fined, they have an incentive to pay you because they want to maintain their license.
So I will add or amend my motion that's on the table prior to a second that the respondent has 90 days with which to pay her fine. 120 days with which to pay her fine.
I'll second that. Oh, good second?
Either way.
Motion made by member leader. Second, I need to read.
It's in the
Okay.
record.
And seconded by member Hoffman. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries. Item number 13, petition to appear, Vicki Peckham, Posh Salon and Spa, requesting the board to allow advanced educational classes for licensed cosmetologists.
Prior to the swearing in of this particular applicant and petitioner, please let the record show that Alex Leader did work for this petitioner at one time several years ago in 2003, but that relationship doesn't affect my ability to make a decision in today's hearing.
So noted.
Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do. Vicki, last name Peckham, P-E-C-K-H-A-M. Could I first request that my husband join me here as co-owner of Posh Salon?
Is there a problem with that? You need to be sworn in too.
swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Dolan, D-O-R-L-O-N, Peckham, P-C-K.
Madam Chair.
H-A.
I'm sorry, go ahead, finish your...
That's fine.
Madam Chair, if each of the board members receive a staff report with a recommendation from staff. The background of this particular issue is the petitioner requesting a variance from the board to be able to teach advanced cosmetology courses or presentations within the footprint of the establishment. In the past, the board has not allowed that unless it was a formal school or was a separate room not within the footprint of the establishment. And the concerns that the board should take under consideration is that normally they require those kinds of programs to be within the school itself, and anything, this would be an establishment that would be allowed to operate like a school temporarily, periodically. And so that's the real issue that's before you today on this issue. The staff report goes into detail of that policy.
Thank you. Before we get started on this most important issue of advanced education, which I'm sure everyone in here has before, the question is, how do we proceed with it? So I would like to do a handout that is just kind of a guide.
Can she give handouts?
If you want to receive a handout, sure.
It's just a petition. For what we're going to talk about.
Do you have copies for every member of the board? And one more for the recorder. We need one more.
Do I need one more?
I can share.
I was going to say.
Yeah,
That's
well,
okay.
Debbie has one for the
I had
board.
one extra. So in preparing for today's subject, we've been discussing this for probably the last year or two. I've been in the salon business with my husband for the last 30 years. So I see a need, I see a requirement, I see licensed cosmetologists that want this sort of thing. So we're trying to put our heads together and figure out how can we do something like this and in compliance with state law, whether it be in the salon or on-site, however we have to do it. So today, we're here asking your advice, asking you to help us to get something in motion for our community. It's been my experience over the last 30 years that there are many, many, many cosmetologists in our area, in northern Nevada, speaking, that are in dire need of advanced education. I have some examples with me today of that. But they can't afford the travel that it might take to out-of-state venues for this education, although they want it and they need it. So the idea is to bring something here and get Reno known for being one of the centers that promotes and brings advanced education not only to our area, but for outside licensed cosmetologists to come and partake and participate. So we're here today for that reason, and Dorlin has put together, following the handout I just gave you, our ideas. So I'm going to let him speak to this.
I'd like to ask you a question. Are you requesting payment for this?
Yes.
Do you have licensed educators?
We have some are licensed, you mean licensed instructors. We have some that have been in the past that are not current. We have
people of high status that have been doing this for years and years. An example is, I'm sure y'all have heard of Bumble. They have Bumble. They have an accreditation that's called In Salon, their network coordinators. And they have to go through certain educational requirements by Bumble to get that certification. So we have 2 of those. They just went to New York's Fashion Week, and they came back. They've got so much to share. So if they're technically not a licensed instructor with the state of Nevada, their credentials are long and experience. So your answer is no. I don't have licensed instructor.
I do believe our laws, though, as far as doing something on this line, is really clear on stating that you need to have a school and you need to have licensed educators to be able to do this. I mean, as a cosmetologist, I do understand continuing education. We have a major problem with that. And that's why we offered that this last 2 years. The board offered it to get people somewhat up to speed. It wasn't even close, but I'm going to ask Mr. Jim now, because when we're doing continuing education, it's not something that we can do legally right now in our laws.
We have a continuing education program for instructors that the different presenters have to submit to the agency. We review the curriculum, number of hours, the instructors' backgrounds, and the technology they're using. And then they're allowed to attend those presentations. What Ms. Peckham is discussing now is conducting regular programming within an establishment. And that's what our laws don't allow at the moment.
Well, and I don't think that at this time, what you're presenting, we would have any control or jurisdiction over. That we could, in other words, if you had someone come into your salon teaching, let's say 4 or 5 cosmetologists, certain things could be out of context to our laws or the way that things should be done.
Is this up for discussion at this point?
I would say yes.
Okay. Well, what we found in the past is, in being in business, what happens, and I think it can escalate to starting out with some classes, and it takes off, and it's really great, and the next thing you know, that's what you're doing all the time. Then you might as well be a school, and you're not licensed and established as a school. However, if you were to take the precedence of demonstrating something, like you're demonstrating videos, or you're demonstrating new shears, and you're selling the shears, and they're teaching the classes, that's allowed. So you can't go into and create a school where there's no school. But however, wanting advanced education, and I think that's huge, because there's instructors that teach you how to wash hair and follow the law, and then there's learning how to cut hair in an advanced way, and we definitely need to see more of that. However, the way it's structured, it couldn't happen in a salon environment under these guidelines. You have to go into a demonstrator, like you're demonstrating, like I said, shears or videos. When you're selling that particular product, you're showing what you're doing. That's a different animal, and it might have to be done off-site. I don't know. I'd have to direct it.
That's where the problem lies, is the establishment itself, the conclave, the contained area, what we call the footprint. That's the actual floor plan, is where it's not allowed for classes because of the definition of the school. What I've indicated to many folks that have talked about this topic, you could have a room that's not within the footprint that you can't do the actual touching and the demonstration. Where they want to go, at least my perception was, that they actually want to have, say, like a stylist do a big demonstration of a new hairstyle approach or something. with 25 people in the room learning that. Our current laws and the way they're defined and the past practice of the board, it doesn't normally allow that. It's when you get a hands-on type of thing. You can teach theory, you can teach how to run the business, how to make money. All those kind of things are allowed in a separate room next door, but not in the footprint. So the transition is where does the board want to go with this philosophy? Do we want to do that? I think you'll get probably a reaction from the schools themselves.
I just think it's a challenge because there's a certain limitation that they can teach in school based on the hours, and the amount of education you're going to get there is going to be minimal requirements that are required. So I think that possibly renting a school maybe is an option until we can work through it in some way.
Are you also suggesting maybe renting a space like after the school closes to be able to go in there? And
No, that still is the same, basically, the same
But
thing
then
we're talking
in
about,
a
whether it's
school
open or closed.
footprint, in a school footprint, it would be allowed because it's licensed as a school.
As a school.
As a
Right.
school, so it has the training rooms and all that. The problem is, what she's suggesting is when the school closes at 6 o'clock or Saturdays, you could rent the training facility there for 6 hours or 8 hours and do your classes there. What the problem comes is when you try to do that in the establishment itself.
I apologize, I thought you said salon, not school.
No, sorry. Yeah,
I-
because
I-
I remember in the past, we used to have advanced classes for clipper cuts or I think one time it was a wedge haircut or
Right.
variation.
But you had
And it was-
instructors
Yes,
there.
instructors were present from the school. You had a licensed instructor there with you, and the students could attend or folks that weren't enrolled.
Mr.
I want to make a statement first. Is I think you all should work on this because I'm not a hairdresser, but I think to make the school smaller than 5,000 square feet, I would love to see that passed so that so that you could do that in your own salons and stuff like that. Give me a chance here, please. And I think that would be important because I think there's advanced classes that need to be taught in a smaller footprint. My question is this. If you hired a lecturer to come in and speak at the salon, and they brought with them a model to show when they're lecturing, is that the same thing?
Yes.
Say it again one more time.
If they brought into the salon a lecturer, somebody to lecture on a style or a cut, and that lecturer brought with them their own model to work on, would that be the same thing?
Yes. Still has a problem.
Well, then how do they get away with it when they do these big salon shows like?
They get a temporary license.
They have a one-time temporary.
One-time license.
So that everybody could do that. Do you have to have the 5,000 square feet at that time, or could it be?
You're confusing a formal school with an establishment.
No, I understand that, but you're saying they have to be licensed to do this, but you wouldn't have to be licensed to be a lecturer.
No.
And you don't have to be an instructor when you're putting a show on the stage and you're selling like Clairol products.
In the law, it
But
provides
again, you're selling product, and you're showing your product. You're not demonstrating how, the procedure is done.
But they do on stage all the time when you do those big shows.
You're selling their product.
Correct, it's a demo.
Yeah. But you pay to get in there and,
It's not classes, it's demos.
So could they do a demo in their salon, then? They could do that and not have a problem?
They'd have to get a license each and every time. I do believe. Am I correct? Ms. Jones?
Yes. The demos that you're referring to within the school, and that she would probably be doing, would be on what they call dummy models. They're on a tripod, and there's a doll head on that. So it is a non-human model.
I'm talking about when you go to, it's been a long time since I've been to one of those shows, but where you go to a show, you're on stage, they're putting product on your hair, they're cutting your hair, and that person not necessarily is
But
an
they are not
instructor.
considered public. Those folks are considered models from employees of that company. They just don't go around asking or taking people from the audience.
Correct, that's what I'm saying. In other words, the lecturer would bring with them their model that they would use and speak about while they're putting on the lecture.
While they're selling their product.
This is the same
And teaching
discussion
in
we had
class.
about makeup artistry.
Yep.
It's exactly the same thing.
That was my thing about the 5,000 square feet that I brought up.
Mr. Leader?
I thought that Ms. Benaldi actually brought up the point the best. And she indicated that it sounds good in theory when it's just one-time situation, but in the event that it's very successful, all of a sudden, every single day, your establishment could very well be acting as a school. And I think that that's where the kind of the issue lies for me, particularly because the education of cosmetology happens in a licensed cosmetology school. When I read through your proposal, I didn't see any reason why you couldn't do what you want to do in a school setting. And one of the things that's so important is that a licensed cosmetological instructor is not just licensed as a cosmetologist, but they're licensed as an instructor. And so it kind of bothers me a bit that somebody could be educating somebody but not have certified training as an instructor. While they might very well know hair or know nails or know some techniques that are ideal for continuing the education of our licensees, the most important thing is that we recognize in the state of Nevada that licensed cosmetology schools have licensed cosmetology instructors. And so there's a confirmation that the information that's being taught is actually being not just taught by a cosmetologist or esthetician or other licensee type of field, but it's actually being taught by a licensed instructor. And so that's really an important component that we don't ever want to circumvent or undermine. It's very important that the people who are getting licensed, or even if they've been licensed, that they're being educated by licensed instructors. And we see that across the board. We see it in schools. We see it in upper education, advanced education. So I'm a little concerned when you said that your instructors weren't going to be licensed, because now they're not only not licensed to do the service that they're going to be teaching, but they're also not licensed instructors. And I thought Ms. Benaldi addressed that very well.
Excuse me, for interrupting. I did not say they weren't licensed. I said they weren't licensed instructors. They are licensed cosmetologists.
And
absolutely.
Is that just always going to be the circumstance? Because one of the deals about a licensed cosmetology school is that the licensed instructors are always, in fact, licensed instructors.
And what is your question?
I'd also like to add to that they also have to have 30 continuing educational credits to renew that license. So it's just an ongoing education for the instructor and the student, so it's always current.
And so I guess what I'm concerned about is when I listen to Ms. Benaldi and now I listen to Ms. Jones, I'm just a little confused on when somebody's going to be taught by somebody who's licensed, when they're not going to be taught by somebody who's licensed. Well, licensed, because when it's happening in a school, we know that the instruction is happening because the person's licensed. When it happens elsewhere, I'm just not quite sure we have that same guarantee.
Well,
That's
if I
a
could
little concerning to me.
interject something at this point, something that Ms. Booth brought up was the shows that are available to us throughout different states that we go to. Sometimes you're in a venue where it's the main floor and there's a stage over here and a stage over here and a stage over here, and there's an instructor or a demonstrator, or a platform artist, whatever you want to call them, and they're demonstrating color, they're demonstrating hair cutting. Yes, they are representing a product, and they are there to sell that product. We all understand that. But the attendee that's there is very interested in the hair cutting techniques, the coloring techniques. We're there to learn and to bring back that knowledge. Those people aren't necessarily licensed instructors. They're representing a company, a brand, a product.
So if I hear you correctly, you're saying that the folks that participate, the participants, are real hungry for education, and so they go to a location for education. Did I hear that correctly?
Yes.
And I think that that's the same thing with your proposal, is that if the folks that want the education within POSH, they're actually going to go to a school, just like you're
Can I
getting.
see, I think, Dorland.
Oh, I know, he's asked a couple times here.
Yeah, you guys should be.
I will relinquish to Dorland.
Thank you.
I'll sit down.
I'm a licensed cosmetologist, and I did go through provisional training as an instructor. I let my license lapse a few years ago, but I went on the website and I looked what was available, and I found the continuing education approved classes that, and I could be misreading this, but Hot Box Salon Plus Workshop in Las Vegas taking place, and it's open. Class dates are open, so I was obviously being an instructor. I'm very sensitive to the Nevada laws and regulations, more so because I've studied them, and I don't want to be here. I want to be here today in this capacity rather than being penalized for doing something that was out of control, and that's the whole reason we're here. Also, I found the CEU provider application on your website, but then frequently asked questions. There's nothing on there, so that's why we wanted to come here and talk. It hasn't been developed yet. We are willing to take this to the legislature to try to see if these laws can be changed. This is one of my clients who had her hair done, and she went in for a trim. So we have a licensed instructor teaching this type of work, and this girl gets massacred. My point is, what do we need to do to bring advanced education to this area? Now, Utah, for example, you don't even need a license to go in and volunteer to work with the students. Nevada's very rigid, and I appreciate what Alex is saying, but we're willing to do what we need to do to work around this and actually bring it to the legislature so we don't have things like this happening based on a licensed instructor, because school, in my opinion, is to pass state board. That's what the requirements are. But anything above that, then you have a licensed cosmetologist, so it's different than an instructor passing a student to get the license, to where they've already done that. And I just want to make sure that we dot our I's, cross our T's with state board to do whatever we need to do.
Okay, I'm getting, and I understand what you're saying in that aspect. And we took before the legislature to get CEUs for continuing education. And then once that we could get that as a permanent thing, we are working with the legislature. Okay, just to let you know that this has not gone by the wayside, or this is not the first time this has been heard. But we were fought heavily just for 8 CEUs. We couldn't get those. All we could get was what we put on the website to introduce it to our licensees. And there's a major fight with that. As you heard, everybody's afraid of going online and doing the little test. And then once we could get this process, this is what we were looking at as in the future. Once we could get this process going where people are more comfortable with getting CEUs, just like a physician has to, they have to do so many every year. A lot of professionals have to get so many CEUs every year just to be able to get their licenses. This is what our main goal was to do. And once we can get that process through, then you can look at continuing education as applying for someone that can give so many CEUs for a class. So it's not like that we're not looking at this, but having one particular place at this point is not what we can do. We are working in that, and maybe you can work with us to help us get to that point and talk to your legislator. But right now, we could only get the 4. It was 4 CEUs, am I correct? And that was for the one-time shot only. It's not. We're done now, and unless we're still in the, I think we still have a few that are in that process. Am I correct?
Yeah, there's about.
That still have to do that. So we have to go before them again with data that says this is working, this isn't working, whatever.
But I don't
We can
think
do
they want
anything.
CEUs for.
Not necessarily.
But this wouldn't, this is the only way that it would,
Well, what we're going to the legislature for is for requirement. They're not asking that this be a requirement. They're asking that they are allowed to teach people that want to learn, that are willing to pay for advanced classes. It's not something that we're asking as a board. They're not asking us as a board to make this a requirement that we send them to these people.
but I'm also thinking that the legislators will take this hand in hand and look at it as if you can't just have people out there saying they're giving advanced education without something
Maybe
there.
they could just be lectures. Mr. Hoffman has a question.
Yeah, my question to Mr. and Mrs. Peckham, then why not establish a school? If you want to do this, if you want to advance education beyond, I understand you said that school is for passing state boards. What about establishing an advanced education school?
That would be a possibility. To do that would spread ourselves a little bit too thin to try to run a successful business and also run a school. I think that would be a bit much for us to take on, not that somebody else couldn't do it. Getting back to the website, I'm just wondering how, is David Bangham, is he a licensed instructor? And this is taking place in a salon with an open class date. I'm just wondering how they get around it.
Exactly. This was
Not seen that, I don't.
This is
hot
on the,
tunes or hot whatever it was.
it's called Form Flow Fuse, Men's Form, Advanced Form, Fundamentals, Fusion, Advanced Fusion. It looks to me like...
Sounds like the inspector has a job to do.
But this is coming off this comes off
No,
the website, and
it's
this
on your
hasn't been approved by state board apparently for this, and you're more than welcome to have this. But it's on your website.
Our website?
Yes, the Nevada State Board of Cosmetology, and these are continuing education approved classes.
For instructors only.
So, Hot Box Salon is a
There's
school.
special programs put on by a particular agency that's been submitted to us, the
Okay.
curriculum, the number of hours. We examine all the instructors, and then we approve the class for CEUs for instructors only. They're not for the general public.
Okay. Well, general public, would that mean licensed cosmetologist excluded?
Yes.
What you're asking for, though, there's really two issues here, and I've said it in the report, I'll say it again. The first issue is that the regulations and the statutes that are in place do not allow general classes like that to be taught in footprints of a licensed establishment.
Okay.
It must be
Understand
done
that.
in a school.
But what about off-site?
Off-site is okay as long as, but if you're going to touch people and actually do a shampoo and stuff, then you have to have a licensed establishment. So I've always said, and I've said this a number of times in different ways, if you do it off-site, outside of the footprint, a building next door or down the block, you can teach theory. You can teach by video. You can do all that. You can do that legally now. But what people want to do is they want to use the salon equipment and establishment stuff and then show you actually doing the customized designs. And our laws don't allow that under this current, the way it's written now. That would take a law change. The board may have a possibility of allowing it. We'd have to do the research to see if the law would allow us to do that. In other words, the board have authority to make a policy to allow that. But in the past 4 years, whatever, they've never allowed it. So our position from the administrative side of the equation is we're following board approach, policy definition, and the laws that are in place. What you're asking for is a change in the policy. The same discussion with the artistry people came, is they want to start an artistry-only school. But they don't have to call it a school, but they want to actually do artistry work. Well, that comes under the jurisdiction of this, and they were in the same problem. You've got to start a school. Well, they can afford a 5,000 square foot facility. That was their problem. So what you're really asking for the board is a change of philosophy and policy, or going back to the the legislature and actually changing either the regulations or the statutes to make it legal to do that. So that's where we are at this point.
I appreciate that, and the reason we're here today is, like I stated earlier, was not to do anything to break the laws of the state board and legislation. With school, there's a minimum amount of hours per week. What differentiates this, based on a school, would be 1 day a week. Now, it used to be that there was a temporary permit you could purchase for a certain amount of time.
There is a section for temporary permits, but it's Mrs. Wynn of the Wynn Corporation led the charge on that. And then they're supposed to be for visiting stylists who are going to do a demonstration, and it's a one-time thing or a 2-day thing, and that's all it is. That's how the casinos and the convention centers get around the demonstration on most of them, because they are stipulated in the law that's allowable. But not ongoing classes constantly. Can't do that. That's where the buying comes.
Can they do an online class outside of their...
As long as it's not an actual serving of a cosmetology service. See, the difference is the shampooing and then the cutting and the designing right in front of you has to be done under certain conditions, under our laws.
They can do it on a mannequin.
They can do it on a mannequin, and you can do that outside the footprint anytime you want.
Thanks.
So what I've said to everybody is, if you want to rent outside your footprint a room, 30 by 30, and hold classes, we can even approve them for continuing education for instructors, because those are what's happening. We get Redken all the time who comes into a school, and they're going to show their product, and they get 4 hours authorized for continuing education for the instructors, because we demand that it can't be product selling. There's got to be at least some redeeming value to the actual training for the health and safety and infection control stuff. And that's what we give them credit for, just the 4 hours. The selling part, they're on their own on that. But they do them in schools. So the issue is, if I were in your place, a little advice from my side of the equation would be, you might find a school who's willing to allow you to use their training center in cooperation with their license that would be allowed, then we would authorize that.
Excuse me, or since we just clarified that, you could have another place with mannequin heads.
Yeah, that was our
And
issue. We were never
and
going
not
to
in the
have live
salon.
models.
Can't be
We were
serviced.
never
Well,
gonna-
not have it in the
Right,
salon
outside.
area. Outside.
That's the clarification we were looking for, and like I said, we just want to make sure we do everything
And
correctly.
great idea. Thank you so much for this suggestion of the school. I love that idea. I love that idea.
I'll then make the motion unless there's other
We
comment.
need a motion.
I also wanted to say, especially if you invite your current students to attend
Of course,
at no cost.
that might get us in the door.
Yes.
I love it. Thank you.
I'm going to make the motion then that, just based on the discussion and the review of the proposal by the petitioners of Posh Salon and Spa, that we do deny the petitioner's request at this time.
I'd like a second.
Motion made by Member Leader, seconded by Member Jones. Any discussion?
Can I have some?
Yeah.
I just want to make sure I understand this correctly. The denial is to do it in the salon, but as far as doing it off-site with mannequin heads, we're okay.
Exactly.
I'll be more than happy to work with you.
Okay. Thank you
All
very
those
much.
in favor? Sure.
Aye.
Any opposed? Motion carries.
Thank you so much.
Do we want to go on to this next case and then have lunch?
Yeah, that would probably be better. Everything else would be just one business.
Well, they came from Las Vegas, so maybe it would depend on when they're flying home too.
Well, if we do it now, then we
No,
can we just
let's
have
do
board
that
business.
one item.
Oh, yeah.
And the rest is
Yeah.
all board.
Okay, item number 14, petition to appear, Melinda Mannion, I believe that's requesting a variance to open a cosmetological establishment in reference to NAC 644.375, place of practice private residence.
Madam Chair, go ahead and get sworn in first, too. Apologize for the confusion.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
I have your full name, please.
Yes, Melinda Mannion, last name M-A-N-I-O-N.
Okay, Madam Chair, one of our elite board members and I disagree on the philosophical positioning of this. We both come to the same conclusion. Go ahead and sit down.
Okay, I actually have handouts too, if that's okay.
Yeah, you can
Okay.
sit down.
Is it in addition to what you've already?
Yes, it is. Well, the questions are the same. It's just a map of the place, so it kind of further
Is it different than
Does it
these?
look like that?
Yeah, we've
It's
already,
different, but it's
Oh.
it's just larger, and I've changed the colors a little bit. So I guess it's
they've
not
already
really
got
much
it.
different. Okay.
the issue at stake for this particular petition is for a variance to the structured law that in our code now, in the administrative code and the statute, that describes when a residence sits against an establishment, that there can be no regular interface to the residence. There has to be separate entrances. In this particular situation where Ms. Booth and I have a light philosophical difference, even though we come to the same answer, is that we've allowed variances to our code, which is fairly clear, which may be in conflict with either a zoning code or a building code and that sort of thing, or fire marshal's regulations. And the issue is that the fire marshal insists under certain connections that there be a certain number of access and egress to allow safety for the people who live there or work there. There is one wall in this design that the fire marshal insists is open, and our regulation requires it to be closed. So that's the issue in front of you. The staff has looked at it, and even though Ms. Booth and I had this wonderful philosophical discussion the last 2 days, we both came to the conclusion it might be a variance the board might be interested in allowing.
I have one more thing to add too. I don't know if I think I did add it in what I gave to you originally, but the building is zoned commercial, not residential.
It's commercial.
Yeah.
Actually, I showed it being zoned industrial.
Industrial, correct.
And then the issue here is it's a loft kind of thing above, and then business's capability underneath. And so the issue is, really it's the fire marshal's regulation that says we can't close that door. I mean, we have to leave it open. And our regulation says it has to be closed.
So since this is zoned commercial, is there anything that we really need to do here?
Yeah, our laws, no matter what is zoned, we don't care. It's a residence.
Whatever it's
period.
zoned, okay,
If
but it
it's
is a
called
commercial building.
if it's called a caretaker's residence, it still is, our law does not allow a residence and a business to be attached like that.
Your husband, he works in the adjacent, or the
Yeah.
other part of the building, he has his business in there?
Yeah, and the other rooms that we see.
And
The
it's
three
all
blank
been
rooms.
approved?
Yeah, it's his business, his building, he owns it. So he currently is operating out of there right now. We have that room specified open, just sitting there waiting. I'm just waiting to get approval and see if it's, if I can even build anything in there, open anything in there.
Okay, so this is a proposal, basically, this is
a
what you
proposal.
want to do?
I haven't done anything
Okay.
yet. I've done nothing yet, so I just want to, before I even do anything in there, I just want to make sure it's possible,
Yes.
I have a question. Because you live above this establishment, where will your exhaust fans be?
They run, this side of the building, actually this whole section.
The hair studio section?
Yeah, I was gonna run it through into this section. There's already an exhaust system for my boyfriend's business coming up from this wall right here. So we were gonna run exhaust pipes to it.
So none of the fumes will go up into the residence?
It goes all the way up to the ceiling, to the roof.
you're going to plumb into existing exhaust.
Correct, yes.
Can I move to approve the variance? I move to approve the variance.
I second.
Motion made by Member Booth, seconded by Member Hoffman. Any discussion? All those in, go ahead. No discussion? Okay. All those in favor?
Aye.
Any opposed? Motion carries.
We were the easiest one to do.
All right. Get your business on.
That was your last one then.
Thank you so much.
Okay, that was the last one we have outside yet.
Okay, so now we can probably take a 30-minute break for lunch. We're till 1:30, how's that?
Well, do we still need Mr. Ward when we come back?
No, he's visiting.
Okay.
I was going to say my goodbyes at the break.
I think he's
I
going to
promised
be
to feed
having
him.
lunch with
I'll
us.
feed him if he wants to stick around.
Yeah.
Thank you.
I just didn't want to take a break
do we
if you
want
were
to-
waiting.
No, take a break and say bye.
We appreciated you being here, by the way.
Very much.
Break until 1:30 at 1:40. And that takes us to item number 15, consideration and possible approval of policies concerning the submission of licensing, applications, requests for duplicates, out-of-state certifications, and translations of examinations. Now, do we need to vote on all of these separate, or do
You
we
can
need
do it,
to?
you can do it any way you want. These are,
Spiders landing on Alex's foot. Hello. Got it?
Don't throw it this way.
It's
You need a hand?
yeah, it's not a jumpy spider. They're fast.
they don't need,
I hope you're not getting this on the record.
I only mentioned it because I didn't want to see people scream and jump out of their chairs.
okay, are you guys done?
Yeah, I think so.
Madam Chair, Executive Director, there are four interim policies that are now in effect that deal with problems we've been dealing with for some time, with fraudulent documents and other kinds of issues that lead to individuals abusing the system and trying to launder licenses on the West Coast that were originally acquired on the East Coast or in another state. All four policies are currently in effect and have been in effect since mid-August. And what we did is we begin to shut down this laundering mill. Let me explain a little bit about how it occurs so you follow why we did what we did. In the state of Florida, we have found that there's a particular school by the name of Hollywood Beauty College, which we believe is selling hours to students, not having to attend. Some of the students never even go to Florida, period. They pay their fee, they get their little certificate, they immediately go down to Florida's licensing bureau, and they get certified. We didn't find out that it was certified until very, very recent. We all thought it was licensed as a nail technologist. What we found was during the process of when we get the certification letters, it says initial licensing, and then it had a date. So the staff for many years have been assuming they were licenses until recently when we were flooded with these things. Generally, the Vietnamese population, there's a few others, and generally nail technologists. I had Jeff Green, Inspector 2, actually review the laws in Florida to see if we could find what was causing us some troubles. And what he found is the nail technologists are not licensed. They're registered. And they only have to have 250 hours. We require 600 hours for the same training scheme. So that's what led us down the path, and we began to see California has a couple of schools that we believe are selling hours, and Florida, we know of one, maybe more. Florida doesn't inspect their schools because they're been taken away from the Board of Cosmetology and moved over to the Board of Post-Secondary Education, and they don't do inspections. So what we have is schools that are just sort of running whatever way they want, and then they get their little registration. We thought it was a license. They come here and they launder it. As soon as they get a license from us, they can either come in for a duplicate because their name was put wrong on the license, and when you check the original files, their applications, that's the way they filed them. But what they do is they come back in looking for a duplicate with a new name, and now they got two. And then they go to Arizona or another state right away and license there, because now it's hard to track where these people are coming from. These policies are dealing with those problems. And the first problem that we deal with is submitting applications for licensure. Some of these folks that spoke English were taking 8 or 10 applicants, filling them all out for them. All they did is sign them. Then they'd stack them and submit them all as a group in one envelope to us. And they would pay the fees, that sort of thing. So what we've done is change the first policy has to do with how you submit applications. We take them one at a time, and that sort of thing. The second policy, duplicate license. A duplicate license, we now require them to prove they either had a name change in the court, they had a documentation that shows a name change, they married, and they have marriage certificate, things like that. So that's the second one. And that is to resist people doing the duplicates only to be helped part of the laundering process. And the third is out-of-state certifications. We were starting to see them bring in certifications in envelopes and handing them to us. We now don't accept any certification unless it comes directly from the state. We won't even sealed envelopes we won't accept. It has to come through the mails. A couple states have now put email it. They email them to us as a PDF attachment. That's okay with us too. So that's the third one. And then the fourth one is the translation examination. What we were getting as translators, we only have 2 in the state of Nevada that we have supposedly, remember that we were always believing that they were court certified. Court doesn't really do much in the certification, so we have no idea whether they've been certified by anybody, to be honest with you. And so what we now say is the current vendor who gives us our tests, NIC, produces the test in Vietnamese language, Spanish, Korean, and English. And those 4 languages, if it's done in those languages, you take it and you pick the language you want, and there's nobody there helping translate it for you. What they were doing is, especially the Vietnamese, would come in, they order an English test, and then bring a translator with them and want to use the translator to translate the English test for them. And what we were perceiving is, can't really say it officially, but there was our belief that these folks were helping them pass the test. And that's our belief. We can't prove it. So the fourth policy shuts that down. It says if you order an English test, you take it in Vietnamese, you take it in Vietnamese, and there won't be any assistance for you. If you have an accommodation under ADA or any of those kinds, you have to submit formally 45 days in advance. We go through all the rigmarole to check everything out. So these 4 policies have been quite successful in shutting down the spigot for these kind of problems. They've been in place, like I said, I think it's the 22nd of August. What I'm asking the board to do is adopt these as routine policies of the board at a meeting for the record. Sooner or later, somebody's going to challenge it, so we want to be able to say that it wasn't just administratively done, that it was done with the board's approval and support. So that's this document.
Do we have any questions? No.
I'd like to make a motion then that we approve the policies concerning the submission of licensing application, the request for the duplicates, the out-of-state certifications, and the policy for the translation of examination as presented.
I second.
Motion made by Mr. Leader, seconded by Mr. Hoffman. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries.
That's good.
Sure.
Mr. Jim now,
Yes.
on verify, like say somebody comes from Ukraine? I mean, all we have is what they tell us, right?
Yeah,
I mean, or do they actually have licenses and so forth?
Some countries, they can get licenses, and they have records of their education. We sometimes have to have them translated. Gloria probably might have a better feel for that, but most of them, we can usually get around the problems. Mexico's a hard one because they claim a high school diploma. They're really talking about the 8th grade. Many of them they claim they can't get the records. They graduated and all this stuff. So we each use a case-by-case basis, which means it may be a long time. We have one case right now from China. It took me 6 weeks to get finally Customs and Immigration to say that because her passport had expired, that it was okay for her to license her because she does have a work card that's still valid. And there's under the federal rules, so I guess it's okay for it to be expired because with China they have a special agreement. They come once a year to the embassy and they renew licenses or passports. So we spend a lot of time in their case-by-case basis, and if we don't really believe they're telling us the truth, we don't license them. So that's where we are with that.
Because I know there's a lot of from Russia right now.
Yeah.
So I'm just curious how it's done. Thank you.
We see Ukraine, Russia. We've seen a few from the formerly Soviet Union, now they're individual countries, Uzbekistan, and those kind of places. Generally, they speak English, most of them, and they seem to. We haven't had that many troubles with them.
No, we don't. We request the original documentation, and then we have it translated here.
Yeah, usually they get them in Russian, then they translate them and they bring them in. They're fine.
Right. Yeah.
Okay, that brings us on to item
We need to
16,
vote.
or what?
That. I made a
No.
motion.
Already did.
Didn't we vote?
I think we just
Yeah, we all
accepted
said
the
aye.
motion, the second, and we had discussion.
Yeah, but we all said aye.
Yep.
You asked?
Yeah.
Oh, we did? We had said.
Were you sleeping?
I said aye. I don't know about
Oh, my
anyone
God,
else.
I'm sorry. How embarrassing. Okay.
I'm going to comment
Should we
after.
ask the recorder to verify?
Yeah, she can read it back to us.
It's a vote. And then you had a comment.
Oh.
Yeah, after the vote.
Oh, my God, how embarrassing.
Yeah, I have that problem.
Hold on.
Should be in
Here, motion made by Mr. Leader, seconded by Mr. Hoffman. Any discussion? All those in favor, aye.
That's my comment.
Opposed, motion carries. And I pose a question. So, anyway.
Item number 16, request by Vice Chair Alex Leader for a review of the Board of Cosmetology mission statement. Do you want to address that, Mr. Leader?
I just repeated the material that we had before. So.
Well, I thought, when we instituted continuing education, that we were instituting that because the mission statement included education as one of our components. And since we do license the schools of cosmetology, education was a very key component. But then when I read the mission statement didn't include education. And so I was kind of wondering, well, why as a board are we mandating continuing ed when it's really not part of our mission? The whole point of us as an agency to protect public safety is to make sure that we do adhere to our mission. So I was really interested in including education in the mission. And then with some of the folks today, kind of seems like education really is a big part of what's missing. And
Would that make you happy?
that make me happy. Well, I like how the mission is stated on number 2. It says that the mission of the Nevada State Board of Cosmetology is to protect the public health, safety, and welfare through education and then it goes into what the mission is, and what the mission traditionally is.
So I can make a motion in that?
Well, if there's other discussion.
I think we've all sent in information to Mr. Jim now about how we felt, and I don't think you were on board at the
I was
time.
on board.
And what I thought, as far as the mission statement goes, that when it says ensuring only qualified persons, that implies that they are educated. I think the implication is there, and I agree with you. I think the implication is there. However,
as an agency, you want to have your mission clearly stated. You want to be able to do things according to your mission. So if I were to say it's not clearly implying it, well, now all of a sudden there's just a difference of an opinion. Whereas if it clearly states education, now there's no difference of opinion and we're all working on the same page.
And I'm going to help Alex a little bit here. I think that if somebody reading the mission statement from any walk of life, at any education level, will understand education's important part. So I don't see that it hurts anything, adds to it, because it does really clarify education also. So I think for the lay person, it might be good for education. I mean, I didn't have a problem with the way it was, but I don't have a problem with going with education in there, making it even clearer.
And yet I have a problem mandating continuing education when it's not clearly stated in our mission. That's kind of where my issue is I don't think we should be mandating something where it's only implied. I think if we are really trying to say that education is a significant component.
This isn't your mandate, though, here. That's just the overall view. But the mandate would go a little bit further. I just think that really the education piece in there makes it really clear to the lay person, cleans it up, takes any little gray out. It doesn't matter to me how anybody else feels, but
I think even with this one situation where we had the salon owners coming before us wanting to teach in their spa, there's another indicator of how somebody is looking at the agency and trying to expand their own business using education as a foothold. And, unfortunately, their application was denied based on other circumstances, but you can kind of see in the industry that people are asking for education. I just honestly feel that it should be part of our mission. It shouldn't be just something that's implied. It should be a part of it, and we should be working towards strengthening how not only the students, but how the licensees, how they view education as being a sincere part of our profession. Ongoing education, I think we talk about it, and we say that we like advanced techniques or we like continuing techniques. But again, I would like to see it spelled out rather than just implied.
Is that our mission? What is the board's what is what we do?
I think what we do is exactly what it says stated with the inclusion of education, because that's how we do it. We don't just do it by ensuring only qualified persons are granted licenses, but we do it through the early process of 1,800 hours, 900 hours, and 600 hours for those key licensees.
And if we have our way, we could eventually get some more
continuing education hours. I feel like if our mission says education, now we can go to the legislature and say, hey, you gave us 4 units of CEUs. Now that education is a sincere component of our mission, who's to say that it can't be 30? And I thought Ms. Jones had an excellent observation when we were talking to the salon. I get charged up thinking about it, because she said that the instructors are required every 2 years to have 30 additional units. And here was this guy saying, hey, we want to teach some folks, but I did let my provisional license lapse.
Right.
It's like, what's up with that? I thought that was just a prime example of why we want education as part of our mission. I feel like it speaks for itself.
We govern schools.
Then I will
want a motion?
Entertain a motion.
I would like to make a motion that we accept the under education into our mission statement, which was number 2, right?
It was no
choice. To insert education and into our mission statement, as recommended by staff.
I'll second. Motion made by Ms. Booth, seconded by Ms. Benaldi.
And they didn't recommend
There was no recommendation from the staff.
Oh, staff has no recommendation. Sorry. No recommendation by staff. I'll amend my amendment. Motion.
Any discussion? There being
that's something that starts right off as the new printing comes out. We're not going to change everything.
No,
in the
when we
past.
have the opportunity, we'll start changing wherever it is that we find it in the system.
Okay.
I would, however, like to speak prior to the vote, that be implemented to our website. So as licensees are saying, oh, I didn't know I was supposed to take that little 45-minute test before I set my renewal down, I think it'll be a great opportunity to give people a little additional heads up.
And I just, not to disillusion you, but I would bet if you polled everybody, very few of our licensees have read the mission statement, unfortunately. It was the sad part.
I didn't know we had one
Let
of those
alone-
on the board. I'm sorry, I didn't. I didn't know anything about it.
But if anybody reads it, they're going to get that information.
All those in favor?
Aye.
Any opposed? Motion carries.
So the wording that's in page 2, in parentheses, is what we're going to do.
Education and the darkened letters
Okay.
there.
Is 7 eyes?
Pardon me?
All eyes?
All ayes.
All
I know you didn't.
That was a nay in other words.
That was like, you know.
No, I didn't hear that.
Okay.
Well, your case was better this time than the last time you presented it.
Yeah, well, I think the fact that we had appeals is actually very supportive of that mission change, to be quite frank with you. I think those appeals would have been minimized had education really been a sincere part of the mission, because I think they would have realized. I think even the
First, you
applicant.
have to realize you needed the education, which some didn't.
Well, I state my opinion, and education seems to be a really thing here, so I didn't say no. So I consider it a yes.
I consider you yes too.
Okay. Item 17, consideration and possible approval with implementation of the Nevada law test. Now, before I turn this over to Mr. Juneau, I do have something I would like to say. Okay? Is that okay? Because I was part of this on the test committee, and I would just like to make a couple of statements here, or anyway, I typed it up. I typed this up for the last meeting, but anyway. The test questions are multiple choice or true false. Each question has been referenced with our current law book. We have made a point to put the reference NRS or NHC codes at the end of each question. This is for our reference only and not to be included on the actual test. It will benefit us in the future concerning the validity of the questions. An examination is only as strong as its security. It is imperative that the specific nature of any item written for an examination be kept in strictest confidence. Disclosure of any information about the examination items to anyone outside the committee constitutes a breach of security and may compromise or invalidate the entire testing and certification licensing process. If items were to become known to candidates, the purpose of the examination would be defeated. I have a confidential sample copy of the test that NIC provides the SMEs or subject matter experts for training purposes. I will make this available after the meeting for any board members that wish to see how the questions will look on our law test. I did not provide a copy for each member for confidential reasons. This was asked at the last meeting, and that's why I wanted to make sure that everybody understood why we did what we did. And I would also like to express my utmost confidence and admiration for the other members of the Law Test Committee. It has been one of the most productive and professional committees that I've ever been fortunate enough to work with. Thank you, Chief Inspector Annie Curtis, and Inspector 2 Jeff Green, and of course, Executive Director Vince Gimeno. And at that, I will turn that over to you.
Thank you, Madam Chair. I have lots of bruises to prove it. Where we are with the test question bank is 50, just over 50 questions. We'll be using 25 randomly selected, and then scrambled. Each person will get the same questions, but in all different orders. I mean, you won't recognize it's even the same test. We did some research as to how do we scramble them, how do we check, get feedback as to the validity of the question, and if it's not working, too many people are getting it wrong, or nobody ever misses it, do we need to change it or not? We also looked into when is the appropriate time to institute the test itself. And these are the findings that I came up with. First of all, the companies that do this kind of work, such as NIC, not NIC itself, but their subcontractors, like PSI or DL or any of those kind of companies, all can do this at ease. All you do is give them the questions, they put it in an electronic form that they need it in, and then they scramble as requested. Secondly, they also can give us feedback as to the validity of the test after they've been run for a while. To say test item number 6 on the master form doesn't work. It's too many people are missing it, and they can't say that it's a valid question. And they can do that. Thirdly, all of the companies, and I did call several of them, suggested not to put it in place at the moment because we're in an RFP process, and that whenever we write the contract for the RFP, the selected vendor, that's when we institute it as part of that deal. And then it'll come through in a nice, smooth process. So that's where we are here. I had committed to the board that in our last discussion, we discussed security processes that I was concerned about that would breach the legitimacy of the test. And once you have a copy out in the public, everybody's got a copy of it. So I indicated that I would come back and let you know the status of the research, status of the test development, and that the committee was ready to implement it and took responsibility for the security of the questions so they haven't gone out into the public. So that's what I'm back here for, is getting permission to proceed. The RFP is in current processing. We will be doing evaluations for the RFP request that went out, the request for proposal. That went out 2 weeks ago? I think it was 2 weeks ago. Anyway, it went out to the vendors. We got what they call a vendor question list already. I've responded to that. That's already gone back to the Department of Administration. They sent that back out to the vendors. We will do evaluations. The committee meets on the 15th of November, and the committee is comprised of 3 people from inside the system and 2 people from outside the system. It's not controlled by me. It's controlled by the Department of Administration. They handle everything from this point. Committee chair is the board president. We have Gloria Alexander on the committee because she runs testing. We have Linda Zaziger, our secretary-treasurer, a second board member that will be evaluating. And then we have 2 outside school representatives. One is Bonnie Schultz, former board member and a school owner, and John Grieco from Sandy Dunham's operation at what's the name of that one?
Academy of Hair Design.
Academy of Hair Design. I had originally asked Sandy Dunham to participate, but she thought since John was slowly, methodically taking over that business, that's her son-in-law, that he would be quite enthusiastic about participating. They're going to be held up in a private site in a video conference on the 15th, and they'll be under the supervision of a gal by the name of Rhonda Miller, who is the Department of Administration project manager for this project, and she will conduct the evaluation process. And so there's a number of categories they have to weigh and give us personal score. It should take about a half a day, and then I don't remember the next step after that, but Rhonda will let me know what we do next. Once the board selects the vendor, then the next step is to draft the contract, and the Department of Administration will draft the contract. It will be, I believe, a 4-year contract with an extension, a year extension on the backside, like we did with this one here. We've extended, I've requested the extension of the current contract for a year, and we don't think we're going to have enough time to put it all operational. So I've asked for an additional 3 months from NIC extending the contract 3 more months to allow proper time for whoever is selected, whether it's NIC or anybody else. And there's 11 companies on our list that were contacted to have it ready to go by April 1st. So that's where we stand now. I'll answer any questions anybody might have.
Mr. Chimno, I really thought that it was a really great way to include the Nevada law for the applicants making application through reciprocity. So while I feel that the Nevada law test should definitely be part of people's initial licensing, I also feel that if you're coming from another state, part of the Nevada law test, for me personally, is to ensure that any new applicant, and I consider that a reciprocity applicant, to kind of understand Nevada law. So I really appreciate the effort that went into it, and I definitely would like to see board option number 1 that's indicated in the consideration for the implementation of the Nevada law, because I do feel that that's more comprehensive for protecting the public safety in Nevada.
Yeah, I just wanted to say, I think that if you want to require it for the reciprocity folks, NRS 644.310 is the NRS that talks about the people coming in from another state, territory, or the District of Columbia. And it says that upon application to the board, accompanied by the appropriate fee, a person that's currently licensed in any branch of cosmetology under the laws of any of a state, territory, or District of Columbia may, without examination, unless the board sees fit to require an examination. And so what I would like to see is, if we're going to go ahead and do this, that we have something in writing that says, maybe a policy that says, for purposes of NRS 644.310, the board believes that all applicants from other locations take this test, and the board, sees fit to require that, for public safety, to ensure the person knows the laws, etc. So that way we have something delineating that, and if anybody, questions us, it's very clear what you're requiring, why, and what your authority for requiring it is.
Do we have to wait to vote on this to write the policy? Does it?
I think you can direct Mr. Dimno to write something, but I just would like to see that the board does formally acknowledge that that provision says if the board sees fit, and if that's what you're wanting to do today, I think we just needed to direct so that it's clear.
Let me offer this up as a way to handle that indication. And I agree with Ms. Bradley that it's probably a wise thing to do, because there's several challenges legally to reciprocity and the definitions. And there's a secondary issue we may want to consider down the line, the differences between the educational requirements in one state that requires 250 hours versus a state like ours, which has 600 hours for the same educational requirement to get a license, which Mr. Leader brought up last meeting about concern. But here's what I would suggest. You could approve this and direct me to draft the policy with consultation with the Deputy Attorney General and implement it, and then bring it back to you next time around in the February meeting. And if you see the need for change, make the change after the fact, and then redirect me to rewrite it a different way. But in the meantime, I think we could draft a policy that clearly states the reason we're doing it is because we want to ensure that those coming from other states understand Nevada law and infection control and sanitation issues of concern to us.
Can we amend that to include other countries as well?
Yeah, anything that's not trained here, we can craft it that way. And so the issue, what I'm saying is, you can pass that direction now, saying that's the policy of the board, and then direct me, working with the Deputy Attorney General's office, to put the proper wording in place. Bring it back, it's already approved, and if you don't like the wording, then we can rewrite it after the fact, but now it's in place.
Mr. Gimno, if I hear you correctly, we can discuss making the change to NRS 644.310 that talks about requiring the exam, that the board sees that as being fit for parties coming in from another state to ensure that they understand Nevada law.
We're not changing the law, because the law gives us authority to do that. But what
Right.
Sarah's asking us to do is make sure that we have a policy that's a little more crisp to be defendable if we get challenged.
And so for me personally, again, I felt when we were hearing the appeals for the citations that we found those folks guilty, generally speaking, we found the folks guilty of violating the NRS today. I mean, those were based on little, like, the one gal, her defense was, well, I asked her, and she said that she did it. So right off the bat, to me, somebody needs to be tested on Nevada law, because that's not like to me, that's not a defensible argument to just come out and say somebody said this or said that. So for me, I would like to see that NRS. Are we then also going to make that NRS part of the regulatory review process too? Is that what
No, all I want is to make sure that you articulate today that if you are intending that all reciprocity people take this exam, I want you to articulate on the record and vote it on it, saying that you're including the Nevada law test for the people applying under NRS 644-310. You are saying that Nevada law examination is something we see fit to require all out-of-state people to take, because we want to make sure they know our laws and that they are, competent to practice with knowledge of those laws. And so that's what I wanted you to articulate on the record, and I think that it would be nice to have something drafted that's approved by the board that says that later on, like a policy, and Mr. Jimno can draft that, just so that it's clear. Because again, I just, when people call up the office and ask questions, it gives the office more authority too to say, well, that's in our policy, we can send you a copy of it, it makes it more clear. It's harder for them to complain because the NRS clearly says that if the board sees fit to require an exam, you can. And so I just want to make sure that today, if you're deciding that you say that. We are saying, pursuant to this, we see fit to require this exam, and we want to require it of all Nevada first-time applicants as well.
Okay, it's basically just reinforcing by a policy what the law already allows us to do.
Yeah.
It makes it crisper and easier to defend.
Do I have a motion? Somebody want to
I'll make a motion I'll make a motion that we approve the board options number 1 and ask the director to work with the AG's office and to prepare a policy and procedures form for the future and bring back to us at the next meeting.
So you want that in there about?
I would just add in pursuant to NRS 64, and you want to ensure that NRS 644.310 is included, so that the Nevada law exam,
644.310.
that the Nevada law exam will be for all reciprocity people and all new applicants seeking their initial license.
This exam pursuant to 644.310 is for all new applicants and all reciprocities.
I'd like to second.
Motion made by member Booth, seconded by member Jones. Any discussion?
I would like to make a comment. I would like to thank all of you for the serious
Okay,
consideration.
this is all those in favor?
Aye.
Any opposed? Motion carries.
I would like to thank everyone for taking my suggestion of returning this test back to the testing procedure to get everybody who's applying for a license, whether they be from another state or coming into the industry, to really understand our laws. Having this back as a test pleases me very much. Thank you so much for the consideration.
And if I'm correct, Mr. Jimno, you had indicated that the first gentleman this morning, the first respondent, was a reciprocity.
Yes, he originally was from New Jersey.
So subsequent to this meeting, he would not have had to have some assurance that he knew Nevada law. Whereas now, not immediately, but when the RFP process is complete, that type of individual could be intercepted. The individual, I mean, somebody who is knowingly or willfully wanting to violate Nevada law could potentially be intercepted.
Well, it wouldn't change anything at the moment. I mean, it wouldn't change it either way. What this does say, though, is what we are saying is that when you come from another state, there are people in the reciprocity viewpoint is, well, we're equal to everybody in every state, but every state's not equal. It's not like a doctor or a lawyer that has similar requirements from state to state. We have really vast differentials in requirements for training. I think cosmetology could be as low as 600 hours, and as high as 2,000 hours. And those are a lot of differences in training. So one of the issues deals with what you originally talked about some time ago about being concerned about these vast differences. The Nevada law test says you got to realize you're in a new state, and these laws may be slightly different than your laws, but you need to know these to be licensed here. That's what the real issue. And most of them deal with, to be honest with you, basic requirements of our chapters. I mean, really basic. Sanitation issues, and really, Kathy, you remember all the tests. They were really based at the law themselves of what you have to live under.
Almost verbatim.
Yeah, we use the same words all the time. The idea is to make sure these people understand when you come here, you got to know the laws. Just because you were licensed in New Jersey doesn't mean anything to us, other than you have the skill to comb hair and use the curling iron and all that. But you understand what the laws in this state require. Now, what we found over the last 5 years, and that's what brought this up and why it was so easy for everybody to accept it, is people didn't know the law.
Right.
And they would have come here and tell you that.
I didn't know.
I didn't know. But you read the chapter.
Right.
But I didn't know. And so that's when you were reading this morning about if you agreed to follow through. And that's really what this is about. Same issue.
Okay, so move on to item 18. Review audited financial statements for fiscal year ending June 30th, 2011.
You're on, Debbie.
Approve for filing with the Legislative Council Bureau.
Get your whips out. Your turn.
Do we
Whips.
do we need to vote on this?
Approve it for filing with Legislative Council Bureau, or if you have any questions.
Anybody have any questions? Okay, do I have a motion to accept it?
I'd like you to make a motion to accept the review of the treasurer.
Do you accept the fiscal year audit?
The whole year, the fiscal year.
Right. I would like to make a motion to approve the audited financial statements for fiscal year ending June 30th, 2011 through, and approve with filing with Legislature Council Bureau.
Motion made by Member Jones, seconded by Member Hoffman. Any discussion? All those in favor? Aye. Any opposed? Motion carries.
Yeah.
Okay, item 19, review treasurer's report for May, June, July, and August 2011. Cosmetology. Have a motion to accept the treasurer's report? Do I have a motion? Do I have a motion?
Oh, I thought you said you had, sorry. Yeah.
I make a motion to accept the treasurer's report.
Thank you.
I'd like to accept it. Second that.
Motion made by Member Booth, seconded by Member Jones. Any discussion? All those in favor? Aye. Any opposed? Motion carries.
I say I don't think you could have sugar next time. There's one.
Okay.
Madam Chair, could I get it back?
Sure. Thank you. I guess we'll have a 5-minute break.
Thank you very much.
more than happy to answer any questions regarding the report. As you know, I give you a specific date to a specific date what happened, pretty much everything that's gone on, and that's where we are. And I think this one was, what was the date on it?
The last day?
October 10th.
October 10th. So everything that happened up to October 10th is there. By the way, one thing added to the director's report is the appeal hearing for Ms. Sandra Smith. It will be scheduled for November the 21st at 10 o'clock in Las Vegas. If anyone is not able to make it, please tell me early enough so I can make sure that we still have a quorum.
I will not be able to attend.
Which date? November 21st.
November the 21st.
Okay, is that on?
Yeah.
Monday.
November 21st at 10 o'clock. Now, I know I'm going to punish the people that come from the north because you have to take the early flight, come down to the meeting, be there in plenty of time for the 10 o'clock start. And you'll be going home the same day.
I am scheduled to be at work that day, Mr. Jimno, so maybe as a last resort I could attend, but at this time I'm not.
Okay, so that's two at this
I'll
time.
be there.
1, 2, 3, 4, 5.
You
See
be
that?
there, Coca?
You
Mhm. Be there.
Yeah, so we'll have 5 members. We need a quorum. And the more we have, the better, but we need a quorum.
And that'll be great, you have some from
The two men.
If I was there, I'd still say.
Mr. Jimno, I have a question while you're doing your director's report here. Something that I heard today, and I just want to, for my own knowledge. When you have a hairdresser and she comes and she gets her application, does her application get assigned to a salon? So you know that Susie Smith is working in GQ Salon?
No. In the applications, when they're initial applications, they usually don't know where they're going to work.
Okay.
They're just getting licensed. Renewals, quite often, they put down their current address where they're working. And they're required by the code to tell us whenever they've changed within 30 days. They seldom ever do. So that's one of them.
Yeah, because I was just wondering, because like, as a broker, I get, when one of my agents, their license renewal comes up, I also get notified as a broker that that license is coming up for renewal. But it's really not something you guys could do because you really don't know.
No, they move around pretty
Yeah.
fast. And
Okay,
secondly,
tell us.
we are collecting right now in the current application processing for renewals. We are collecting email addresses so we can be able to e-blast notices and things like that. But that takes a while to get that data bank in place. It's taken 2 years. The last thing you might be aware of, we've been going through a 35-month repositioning of every single license. At the same time, we've been going through collecting corrected data for each of the licensees. Under GL Suites, we have somewhere between 70 and 75% accuracy of the data. We're now working our way up towards 98, 99%. But that takes a lot of consumption of time. Secondly, if you could picture a python who just swallowed a big pig, there's this giant lump that has to be digested. And we're now 2/3 through the digestive period. We've got about 12 months to go of the 35 months. And so what's happening is we have this giant lump in the middle, and it's starting to shrink as we get towards the end of the game. When we reach that 35th month, we should have everybody repositioned, all the heavy loading in the system gone. We will be able to, the only real lump we'll see after that will be the licensees, licensed establishments. And over a period of 3 or 4 or 5, 6 years, we'll see them be repositioned because every time they change hands, they position to a new date. Before they were all June 30th expiration date. So you're starting to see that coming together finally. It's been a long, slow process, and it's very tedious, but we're seeing it. What you'll see in probably another year and a half is that I'll have the confidence in our data bank that we can then, remember those thousands of files we have in those roller files? We won't need them again. It'll be all done, will be paperless on that side. So that's where we are at the moment on the status. we were way behind, as much as 8 weeks behind in licensing from the application coming in to the time we cycled out. We're now down to somewhere around 2 weeks, give or take. So that was a very traumatic period. We spent a lot of time correcting, and we're in much, much better shape than we were before.
And I'm not understanding why that happened with going to the birth dates.
Well, a lot of reasons. One is the repositioning took time. The correction of the data from one computer system to another took a second chunk. Staff did not understand what was causing some glitches. We finally figured out what all the glitches that was slowing the system down. We fixed those. They were fairly easy fixes once we figured out what they're doing. And then just the new employees, turnover and stuff like that. And everything just built on top of each other. So we've identified those issues, slowly fixed every single one of them, and now we're shrunk down. It did cost us a little money from in temporary employees. We had to hire 4 for a while. Now we're down to 2. And 2 are filling vacancies that we're paying attention to. But it's come back to normal speed. We just did a workflow study, which is an engineering design, where they measure how many widgets we handle in a particular kind of category, and then how long does it take to handle a widget, and how many people would it take to do the work for a 12-month period handling that many widgets. So the formula is almost ready to finalize with Nadine Griego as is working up the numbers now. How many staff persons does that mean? And we'll know whether we've been staffed, understaffed, on staff, or overstaffed. My sense is that we're going to be in really decent shape in about another 12 months, because that's when certain activities are no longer needed to be done. Building files, changing them out, copying. They'll all go into the electronic file. And then once they're there, we can reproduce any file we have automatically very quickly. So that's when we get to be more paperless. It's traumatic to make conversions like this. When you weren't all here at the time. When they first said, well, we should go to a DMV kind of licensing. That is a monumental task, and we're almost done with that now. So that's what caused much of the backlog.
And on the average, what's it taking for you to do right now at this time to do one application? Or you don't know that yet?
There's 12 steps, 12 or 15. 15 steps that has to be done from the time you take the application, make the first transaction of the deposit of the money, and then what the next step is, on and on and on. And when you push the final step, which is punch the button and it prints the license out the other end, it takes a while. It's about, really from start to finish, about 15 minutes per license.
Now, and we would never put somebody in here, you would never bring anybody in here that you had their money in the office. And if it's taking, like, one of them said about 8 weeks.
It's possible it could have, but their license is, once they make the payment, and we have a record of that, the inspector's first thing to do is ask about that.
And then, so would you go through all those envelopes, or are you checking the money in immediately and then going back doing the process?
But the first step is to put the transaction in the meter.
And then, like, my example, when I renewed my license, I kept the receipt and actually put it with my expired license and just left it there, so the next time the inspector came into the salon, she saw it and noted that it was paid
Never
for.
a problem.
So if you do it online, or what I'm thinking is somebody writes a check and mails it in?
You have to have a money order.
So you would have a copy of that money order? Okay.
Yeah.
It's a little bit different than the real estate division, because I can mail a check in. They better not bounce a check.
One of the reasons you want to do that is security. I don't know how the real estate...
I just write a check, send it in.
Yeah. In our case, we get a lot of fraudulent documents and stuff, so everything's got to be checked. But most of the people that you see here, when the inspector comes in the door and says, where's your license? And they say, well, I sent my money in. First thing is they call the office and they go into the computer and say, did we have a transaction on that license being started? And if the answer is yes, they don't sign them.
That was just kind of my question. At what point did we know when somebody was in there? So you're saying the minute it comes through the door, it's logged in?
First transaction is deposit the money in or record the money order or the credit card or the debit card.
I do the same thing as Mr. Hoffman. Because, in fact, I think that's kind of what we're advised to do when we do renew our license.
Yeah, the lady I
It looks
talked
like
to
it's going
at
to
the
be
counter,
over.
that's what she said. She said, just keep a hold of your receipt.
I always
We've
put
been
it right
having a look at it.
with my license.
And in some cases, you know, they send their license fee in and they don't send their picture. In that case, we're going to send back everything that you sent us, your money order, your renewal form. So it's going back to that person. We don't take their money unless we're ready to process it. So that could take another week or two to get it back to them, and then they have to get it back to us. So there's a number of reasons why it could take, a long time to get your
Yeah,
license.
if somebody was in that process where they forgot to put their pictures in, and do you have to put pictures in every time?
Yes.
Yeah.
No, okay, so there should be no reason somebody could forget
Yeah,
that.
that's the same as saying I didn't know. It was
Yeah.
the rules.
What you run into periodically is people who say, well, I started it last May, but they had it back 3 times because they forgot to
Right.
put the money order.
Right.
They didn't put the pictures in there. Or they forgot to sign something. And we won't start the processing until all the parts and pieces are there. And so they may very well been there 5 months because they can't get it right.
But whether it was deliberate or whether it was
Yeah.
accidental, they've drawn out the process.
They get charged late fees, right?
Yeah, they get past certain time.
Can we move on and make this a discussion maybe outside?
I was just going to quickly ask Mr. Jimno if you expect, you had said that you wanted to extend the current contract by 3 months with the current vendor
Yes.
for the testing. Do you expect to be gouged
No.
by fees? No.
The contract extension's been for the same price we've paid for the last 5 years.
Okay.
We just extended the expiration date, all it is.
Okay.
Moving on to item 21, testing reports, testing activity report from May through August of 2011. Is there any questions? Moving on to item 22, chief inspector's report, inspection unit activity reports from May through September 2011. Any questions?
Did a lot of inspections, very good.
Comments? Okay, there being none, we'll move on to item 23, annual election of board officers.
No gouging, fighting, hair pulling.
No,
Do we have to nominate people?
I would like to make a recommendation with with what the officers are right now. I believe all the same people, they can respond. But for myself, I would like to continue in the chair as president, and I would ask for a vote to keep it as it is.
I make a motion that we leave it as it is.
I second that motion.
Motion made by Member Booth, seconded by Member Hoffman. All those in favor?
Aye.
I guess you should ask a discussion. But, any opposed? There being none, board members are continuing to be the same. That would be Linda Zeziger as Secretary Treasurer, Alex Leader as Vice President, Kathy Ditzler as President.
Thank you.
Thank you very
Thank you.
much.
And then I just like to always mention publicly that in our law book, the secretary treasurer are 2 positions, and we have elected to combine them and elect 1 person for that combined position. So at a future election, that secretary treasurer position can actually be designated as a secretary and as a treasurer.
I think she does a great job as both.
It's like getting 2 for your money.
Yeah, I did.
Okay, item 25, comments by the general public.
24.
Oh, I crossed it off. Comments by board members in future agenda items, sorry.
I was noticing, sorry, on the license, right now it still says Gibbons. Are we in transit?
Transition.
Yeah. For Sandoval to come on there?
Yeah, we use up the forms we have, and then we'll.
Because my clients all bring it up.
Yep.
What's up with it?
Yeah.
Unless you
Well,
wanna-
we don't want to waste our licensees' fee income resources, so we're using up our supplies.
There we are.
So conservation, we're green.
We're helping the state.
I also had a question too by a board
Gloria,
member.
before you guys get off that, Gloria said that we are using the new license.
Yeah,
That
well,
has the right.
people are replacing.
Get a duplicate, you can request a duplicate.
Yes. I have a question regarding establishment license renewals. I know that for the estheticians, manicurists, hair designers, and cosmetologists that we take a test. I would like to recommend for discussion at the next meeting that we look at establishment license and put on some questions for them as well to reiterate that you don't hire people without a license. True.
Okay, I think you have to probably explain that a little bit more for me.
Okay.
Are
When you
you
get establishment
asking for a
for
committee?
discussion, yes,
You want a committee?
yes,
Okay, so you want to head up that committee?
I would love to.
Okay, do we need 2 more members? Go on that committee?
I can be on it too, it doesn't matter to me.
Okay,
You got your members.
a committee for,
Cosmetological establishment licensing requirements and to include possible testing.
Correct.
did you get all that?
Yeah, have somebody else take care of
It can
it.
all be done by phone, too.
Yeah.
Okay, and you'll bring back a report?
As long as it's posted as a meeting, you can't have a meeting without posting the agenda.
It's a lot more complex than you think.
We're just going to have a coffee.
What I wanted to try to understand is, what are we testing?
But we have to go and test on sanitation, which is one of the most important things in our business. But when you
Are
apply
you-
for established license,
But
it seems to be a recurring.
Okay, so let's back up then a little bit. On the, you're wanting them to have a special test for salon owners. Are you having them come back now, that anybody that is a salon owner?
I was suggesting that the same way we renew our license online, establishments also have a little pass or fail test on.
See, we can no longer have that after this time. It has to go before the legislature.
Okay. All right, well, then
And what
that's
did you start a committee for?
Well, because you have to get a fact-finding.
Yes. Yeah.
Well, basically, I think what that fact-finding mission is that you're reviewing NRS 644.260. And right now, establishments is not part of that group of licensees.
Right.
So currently, the law does not include the issuance of licenses to an establishment that would warrant a test.
And I'd like to ask on establishments too, of something that I heard here today. The lady said her establishment license is from the date she opened her salon, and then her license is from her birth date. Why not have the establishment license and her license the same day? Why not?
They're 2 separate laws, they're licensed different times.
Well,
And
2
one is for 2 years, one is for 1 year.
Oh, okay.
And 2, they could be corporations and have several members.
There's 8,000 combinations of business.
Of names, birthdays.
It just seemed like it would be easier if you had to remember on your birthday that this one was due, and
They send the notice 90 days in advance.
even
There's
for
nothing
the,
to
for the
remember.
establishment ones too.
Yeah.
Oh,
Well, the other thing is that, there could be more than one owner, so it could be confusing too if you pick, which owner would you pick for a birth date?
well, when somebody comes
No,
in.
we changed that law. The new law under SB 193 says that licensed establishments will be, those that are already there will stay where they are. They're every year at the same time, June 30th. In the future, when the license changes hands or initial license is given, the date that the new license is given is what starts the year period for them. So they'll spread out, and it'll be like a driver's license again.
But you are giving them that
Yeah, we notify everybody 90 days in advance.
Okay.
You know, Mr. Jimno, I think the deal is with that is that when people receive that 90 days advance notice, fill it out and send it in, rather than waiting until the deadline to take care of it. I mean, it's kind of the age-old adage, it's like don't wait until the expiration date to turn it in. Turn it in when you receive it.
I can't tell you how many have come in on the very last day, and it happens to be a holiday or a weekend or Sunday.
Ms. Jones?
What exactly would you test them on?
Well, the same reoccurring problems about having people working for them without a license. Is your responsibility
You're saying
or
a
not?
law test, basically, is what you're saying is a law test.
And how do we test supercuts international?
Well, and isn't the cosmetologist in charge? I mean, they're going to be taking the
That
law
should
test
cover
and
them.
and that's the person that's supposed to be ensuring that the law is followed. Not that the owner isn't, but I mean, whoever the cosmetologist in charge is, that's the person that's supposed to be making sure the shampoo pools are clean, and that person will have been tested. I'm looking.
That's all committee stuff. It's all committee stuff.
I'm looking at NRS 644.340, and it's talking about what you have to do to have a license as an establishment, and it talks about making a form, using the forms provided and making an application and paying the appropriate fees. It doesn't say anything about tests, and then I think Mr. Leader pointed out in 260, it also doesn't mention a test for a cosmetological
We'd have to change
establishment.
the law.
So I'm not sure it's something you can do. I think the idea is that it's covered because if the owner is a cosmetologist, the owner knows the law, or should.
So
If
should I just
the
dissolve this committee?
cosmetologist in charge also would know the law. So in theory, there has to be somebody on the premises, or else they're in violation of the law.
This money in a salon that they never go to.
Yeah.
So
I know, it's just like this little girl here that was admitting the things she was admitting to. She could have gotten into a lot more trouble, really, if we could have cited her, because she was admitting to a lot of,
Ms. Jones?
I have another item for discussion. I see a new trend in our meetings of students attending our meetings, and I wanted to recommend a way for us to be able to supply the 4 hours or 2 hours that they are here, being present for one of our board meetings, to give them some kind of credit for it, to encourage more students to come.
I would like to address that. That used to happen,
I know.
and they abused it. And so therefore we had to take it away because they were coming in, signing in, and leaving.
Well, I wasn't speaking about signing in and leaving. I was having them to be here at the end of the meeting to give them a certificate of compliance.
Madam Chair, I disagree with the philosophy. I think it's a giveaway program. It was not productive when they were using it. The young people coming to stick around for a while, they never really learned anything. They got several hours taken off their requirement. And I think that it's better time ventured in the classroom where they belong, that learn skill, because I don't think whether it's non-repetitive or whatever, they're not learning it as much as they should. And when they come here, it was, in my opinion, it was, aren't we important for the girls to see? And that was the wrong rationale behind it. The rationale is, what do they learn here if they're here? Now, the one school that comes, they come on their own. There is no credit for it. So they come, then there's real interest. But the rest are coming because they were supposed to. They had to. They were told to.
Mr. Jimno, I feel that the philosophy is, and Ms. Jones, with all due respect, I think it's the same thing as we saw with an establishment wanting to educate within their own footprint. The whole point of having the cosmetological school is that is where the education takes place. It doesn't take place in a room down the hall. It doesn't take place in a meeting. Yes, it's an educational environment for them, but the learning of cosmetological services happens in a licensed cosmetological school.
Right, I was just offering an opportunity for them to understand what goes on during a board meeting so that when and if they should ever have to appear, God forbid that they would want to after watching us in progress, that it would be not a surprise. it would be something that they can discuss, if they know, by the way, I've been to a board meeting, I wouldn't leave your shares out.
I think they should come of their own volition and be here because they want to be here, not because they're able to deduct hours from their actual on-site location education.
When I was in beauty college and graduated in 2000, we had the opportunity to come and see a board meeting if we wanted to. Half the school would not go, they were afraid. And I think that was my main purpose, was to get rid of that fear of the board and really understand that we're there to represent them and the public. That was just my recommendation. And it wasn't for a whole 8-hour day, because they come on Mondays when schools and salons are not open. And credits were limited to 4, I believe. No one was ever given the whole day. And they had to have been accompanied with a teacher.
I also feel that if you make the exception for them to get hours at a board meeting, when they're not really participating, unless there's public comment participation, you're now going to be opening up a can of worms for, do I get my hours when I go to a trade show? Do I get my hours driving to and from beauty school because I'm clearly intended to go to beauty school? I just think you're starting to deviate away from the point of the licensed cosmetological school, and that's where the education takes place. I think you make that concrete sense, and there's not a deviation.
With all due respect, as an educator from about every school here in this county, I see that as an educational tool. I see that as an opportunity for a one-time shot in a 2-year program. I'm not looking for every Monday come in and get free credits. I was looking for another avenue of that educational progress. I can't teach that in a classroom, but I can put my students in the audience and let them see us in action for 2 hours or whatever it is. So that was the basis for my recommendation.
Ms. Azar. I don't know, Mr. Jimno, if you were with us at the time one of the schools in Vegas came to us and wanted us to approve if they went to a trade show or if they worked in the front selling products. They wanted to be able to give them credit. I don't know, Gloria, if you and I were on the board at the same time, but it was a big thing because the schools, they didn't have to teach that much and they didn't have them working on the floor.
They even got expanded where they would go to high schools to recruit students, and they want to get credit for that. Yeah, you guys had gone through it, and I came second.
Because it's come back up several times.
It's coming back all the time.
Well, and I think we had a circumstance where a school gave hours for when the students helped her move.
Yes.
They boxed up some stuff, they moved around the corner, and students were reporting that they got 40 hours worth of credit. So I think the intent of what you're saying is a valid intent. I just think that it really opens the doors for some confusion, similar to what I think Ms. Bonaldi said to the petitioner who wanted to teach in their salon, is that it sounds good in theory, but all of a sudden the business component of it is going to take off, and lo and behold, you find that your salon is now a school.
Okay, I'm to understand that a couple of hours during a board meeting for their entire school program would open up a can of worms and invite other things. Is that your concern and fear? Is that what I'm hearing?
Well, it's not a fear-based decision. It's just saying that
today anyway.
I think that we need to probably move on to that. I'll move on to the next subject, unless there's some more future items, agenda items that would be wanted to be discussed.
I mean, maybe this can be added to an agenda, but you can't make a decision today anyway because it hasn't been a noticed item. So if it's something that you would like to request be added to the agenda, I think you can talk to Mr. Gino and he'll add it to the agenda, and then we can have an actual discussion.
I probably won't. They're so close to it. I'll leave it as is. It's a matter of record.
Okay, then we'll move on to item 25, comments by general public. There being none, I guess we have no comments. And if there's no further business or no objection, the meeting will be adjourned.
Remember, there's a secondary meeting, so after everybody leaves, we have a short meeting of the 2-tier group.
There being no objections, the meeting is adjourned. 3 o'clock.